Your Honor, today we have a hearing in the matter of CFI 045/2017 Actina FZCO. I'll repeat. Sorry, Your Honor. Your Honor, today we have a hearing in the matter of CFI 045/2017 Actina FZCO versus Standard Chartered Bank. The applicant is represented by Simmons & Simmons Middle East LLP. The lead counsel is Payam Baheshti, assisted by David McDonald. The defendant is represented by Mr. Sayyid Mushtaba Hussain, assisted by Shakar Jayagovind and Nandini Tiwari by Emirati Legal Law Firm.
All right, thank you very much. I went through most of the documents filed in this folder, and I have a good background about the application and the reply to the application. So maybe the applicant may proceed.
Thank you, Your Honor. I appear on behalf of the defendant applicant, Standard Chartered Bank, and my learned friend, Mr. Sayyid Mujtaba Hussain, appears on behalf of the claimant respondent. I'll continue in my submissions to refer to the parties as claimant and defendant, it being acknowledged that the defendant is the applicant in this case. The application before Your Honour today is for immediate judgment against the claim pursuant to Part 24 of the rules of the DIFC Court. Before I proceed, I just wanted to make sure that the schedule of costs has been received, because there was a few issues. Thank you. My submission this morning should not take longer than 45 minutes to an hour, but I'm going to refer you to the skeleton argument, which is quite a bit more detailed than I usually do, but I thought it might be helpful. Essentially, what I would do, the submission will cover the following headings. First, I provide a summary of the facts insofar as you need it. If you don't, I will stop that. Second, I will recap the test for immediate judgment pursuant to Part 24. Third, I will set out the grounds upon which the claimant's case must fail at the immediate judgment phase for no cause of action. Fourth, in the alternative to that, if Your Honour finds that DIFC law does apply, the claim I will submit is time-barred, save in one respect, that is in respect to the allegation for fraud and fraudulent misrep. The fifth point is that even if those claims are not time-barred, they have not been pleaded properly or at all. And finally, I will close my submission with the submission regarding the misrep and fraud claim and how that is not properly pleaded. The application relies on the witness statements of Robert Loosley and Sabara Simon Hunt, who are legal counsel within Standard Chartered Bank, which are in the bundles. Very briefly, because I assume my learned friend is going to cover these 2 points in quite a bit of detail, but he makes quite a big part of his skeleton deals with the fact that an amended defence has not been filed by the defendant, and also with respect to the timing of immediate judgment, etc. I'm not going to deal with those points unless you would like me to.
I want to understand why the defendant decided not to do so. So what is the situation right now? What the position of the defendant to follow the judicial officer direction to submit the amendment defendant? So.
Yes, the defendant had filed a statement of defence.
Yeah, the first one.
The first one.
No, we're talking about the amendment.
Yes, the amended defence was not filed because nothing in the rules requires us to file an amended defence before the before filing an immediate judgment application. I think an immediate judgment application can be brought at any time. In any event, the basis of this immediate judgment in our submission doesn't require any further defence or any defence at all, because the points that we're making are with respect to just one fundamental aspect of the claim. And if we can deal with that, and then the claim falls away.
The only thing this court would like to understand, did the defendant ask permission from the court to extend the time for filing amendment defense? They didn't, right? So there is a direction from the court with a time bar to submit.
The hearing, the judicial officer's ruling in the hearing was very clear that there was no need to file a statement of amended defence until after the immediate judgment application.
This is where I didn't find. There is no clarification when. I mean, there is a direction to file, but they didn't say there is a permission to file it after the immediate judgment. So this is
it was during the hearing, which is recorded. So if
I mean, in the direction itself from the judicial officer Nasser, he gave permission both to the claimant to file amendment particular claim and give a permission. This is my understanding. That's correct, Mr.
Yes. Yes.
Give permission to the defendant to file amendment defense. And that was not fulfilled by the defendant so far. And I'm not sure if there is a time bar with this, or it was open. But what came to me is that the defendant did not ask any extension of time to do so, did not clarify their position. They filed, of course, the immediate judgment 1 day before the CNC. So this is why the judicial officer gave a direction. But anyway, the purpose for today not to deal with this, just to clarify the issue.
Yes, exactly. I mean, just very briefly on that point, the understanding from the hearing was that the immediate judgment application would stay the substantive process. And part of the reason for the immediate judgment application is to stop the costs of the trial itself. But I understand your question. If there wasn't a direction, we will perhaps find the reference in the hearing to that being the understanding. It was certainly our understanding.
Okay.
Thank you. Would it help if I very briefly summarise the factual background?
Sure.
With all respect to my learned friend, some of these points are not agreed, and I will try to highlight those points that are not agreed in this summary.
Especially the 2013, I understand.
Yes, exactly.
This is the main fact.
Yes. The claimant was a customer of the defendant at Standard Chartered Bank Burger Bride branch. The claimant, through Mr. Bijit Ideas, was the main shareholder of the claimant company and made all major investment decisions on behalf of the claimant. He decided to enter into this structured product, which we have called the YDA. The YDA was essentially a product which linked to the performance of an index. It doesn't really matter which index, but for your information, it was tracking the performance of currencies in G10 countries. It had in it a safety structure, which is commonly called a capital protected structured product, so that ultimately the client should not lose more than they put into the investment. That was triggered during the financial crisis, and the structured product essentially stopped performing. But the capital invested into the structured product was protected. However, the claimant decided to leverage that investment. So clearly, if one has 10 dirhams, you can invest it, but if you borrow another 20, your returns are going to be much higher, but the risk is higher.
In our case, the 1 million.
Correct. Yeah. The investment was 1 million and the borrowing was 2 million. The claimant also decided to fix the interest rate on the loan by way of an interest rate swap. And that is, again, a very prudent action that one might take if one's not clear about the ups and downs of the interest rate market, to fix the interest. In the midst of the global financial crisis in January 2009, the trigger was hit because the trading in these countries was too volatile, the protection mechanism hit. But that did not stop the claimant's obligations to pay the loan and the interest on it. Even though the interest was fixed by the interest rate swap, it was still a liability. The claimant decided to unwind the YDA. The option would have been to just let it run for the course of its life and then return the capital at the end. But he unwound the YDA and put the proceeds into a fixed deposit, at least so that he could make some interest. The unwind was carried out on the 18th of February 2009, and the proceeds were placed then in that fixed deposit. It is very clearly the dispute over whether the claimant was missold this product. He didn't understand it, or it wasn't suitable to his needs, or he was misrepresented into borrowing money to invest. But that's a factual dispute which I'm not going to argue.
It's a factual dispute.
Exactly.
Whether he was following the advice from the claimant or he was making his own decision.
Correct.
These are the main.
Yeah. And that's not the purpose of today's application. I do hope that my learned friend would acknowledge that in the submissions. We're really here just to decide whether there is a point of law that can be ruled upon. In any event, the defendant denies all those claims of misrepresentation and breaches of any of the laws if they were applicable. The claim on the test of summary judgment has no reasonable prospect of success. That's the first limb of Part 24. The second limb is that there's no other compelling reason for the case to proceed to trial. And my duty to Your Honour today is to demonstrate that there is no basis for this claim, there's no reasonable prospect for it to go to trial, and there's no other reason why it should. The fundamental, basic core of this application is that the claimant has based his entire claim on DIFC law. And the simple basis of this application is that there is no possible way that DIFC should or could be applied to this dispute. And I will seek to demonstrate that today. However, if that argument is not convincing, then I will also demonstrate that the vast majority of the bases of the claims, the different laws that my learned friend has put forward, are time-barred and they cannot be brought because it's too late, except in respect of fraud allegations and misrepresentation under the DIFC contract law and DIFC law of obligations. But I will also submit that those have not been pleaded in any way sufficiently to allow this case to proceed. Turning to the first point, the core of our application, which is that DIFC law does not apply. The relevant transactions and the relationship between the claimant and the defendant had no connection to the DIFC. That's just a point I'd like to make in the beginning. Leaving aside the technical arguments about the jurisdiction of the DIFC and applicability of law, none of this happened in the DIFC. There was no relationship between the staff members of the DIFC branch and the claimant. I think it's very clear from the submissions of the claimant that that's understood. The claimant fundamentally misunderstands the nature of how applicable law works. The claimant's claim was set out in its particulars of claim dated 20th of September 2017, and in that the claimant alleged breaches of DIFC regulatory law, number 1 of 2004, I'll call that the DIFC regulatory law, and various breaches of the DFSA Code of Conduct, business module. The claimant then...
That was the initial statement.
Correct. And the second particulars of claim, which were amended later in January, were to add some additional bases of the claim. And in those particulars, again, entirely under DIFC law, it was put forward that Article 29 of the DIFC Law of Obligations had been breached, that Article 48 of the DIFC Law of Damages and Remedies had been breached, Article 40 of the DIFC Contract Law had been breached, and so you have allegations of breach of the DIFC Regulatory Law and a number of other DIFC laws.
So the basis of the claim has been modified or been added, right? The basis.
Correct, yes. So the different grounds of...
Not new claims.
They are additional bases, yes, exactly. I don't think it's agreed that the claimant is not saying that an additional fact pattern is relevant. I think they're just adding...
Clarifying more clearly.
Yeah, exactly. Okay. But again, the emphasis there is that it's just DIFC law. The claimant submits that the cases that dealt with DIFC law and the regulatory authority of the DFSA applied here on the basis of the court's interpretation of its jurisdiction under the cases such as Corinth and Barclays and Investment Group Private Limited versus Standard Chartered Bank. Those cases are strictly about the interpretation of the judicial authority law. And the judicial authority law states that the DIFC courts have exclusive jurisdiction over matters involving centre establishments, and is accepted that Standard Chartered Bank DIFC branch or Standard Chartered Bank as a legal person is a centre establishment. There is no denying that. In fact, that was the position the bank took in IGPL and Standard Chartered Bank, and there's no indication that that position is ever going to change. However, the basis upon which the court found that the DIFC court had jurisdiction in those cases is a very different question to whether the DIFC court should always apply DIFC law to every case before it. And that's what my learned friend seeks to submit. Can I refer you, perhaps now, or if you wish to make a note, to paragraphs 16 to 19 of the witness statement of Robert Loseley. That is at bundle 1, tab 11, page 219.
Yes. Thank you. Page?
It's page 219.
Yes.
Of tab 11 of bundle 1.
Paragraph?
Paragraphs 16 to 19. I'll allow Your Honour time to just read that, and I'll make some comments if that's okay.
All right.
Thank you. Essentially, the point that's made in that section of the witness statement is that there's a very clear distinction between this free zone, the DIFC, and outside of this free zone. It's commonly referred to as onshore and offshore, as I'm sure Your Honour is aware. The applicable law, regulation, and supervisory oversight of the financial free zones, such as the DIFC, are absolutely separate and distinct from the applicable law, regulation, and supervisory framework in onshore UAE. I think that's the entire purpose of the DIFC. I don't think it's controversial that the DIFC is subject to its own civil laws, not criminal, but civil laws, and outside of the DIFC is subject to laws of the federal laws as well as laws of each of the Emirates. DIFC law is defined by the DIFC court law of 2004 as, and I quote, law made by the ruler, including, by way of example, the DIFC court law, as applicable in the DIFC. There are numerous provisions in the laws of the DIFC as well as in Dubai law, Dubai legislation that demonstrate that DIFC law is distinct. I have referred, Your Honour, to those paragraphs of the witness statement of Robert Loosely. I'm not going to go through them again. You've read them, and my submission is that they're very clear that there is two different legal systems here. In addition, the regulatory oversight of the DFSA is an important factor to consider as to whether they apply to this dispute, on the basis that the claimant suggests that breaches of the DFSA regulations are also in play, and so therefore should be considered. I refer, Your Honour, to paragraphs 26 to 32 of the same witness statement. 26 to 32, that's quite a long section, but perhaps if you'd like to read it, I'd allow you some.
No, I went through it just.
Okay, yeah. Thank you. Essentially, the point there is that the DFSA was established by DIFC Law Number 9 of 2004 and is solely responsible for the regulation of financial services in the DIFC, only the DIFC. The DFSA's powers as a regulator are conferred to it under the provisions of the regulatory law, and that law makes it clear that the DFSA may only regulate financial services carried out in or from the DIFC. And I just suggest that we quickly turn to Authorities Bundle number 1, tab 9, page 42. Article 8.3. Yes. Each one of those provisions it very clearly articulates that the powers, functions and objectives of the DFSA are limited to the DIFC jurisdiction. You'll see in our skeleton argument that there are numerous other references to supporting that proposition. It is not the DFSA that regulates activities outside of the DIFC. It is the Central Bank of the UAE. The relationship that governed the claimants with the defendants was not subject to regulation here. It was very much an onshore activity. And the distinction is very important for financial institutions who are based in the DIFC but also have a presence outside, because the terms of their license outside of the DIFC and within the DIFC are different, so they can perform different activities. So, for example, many of the DIFC financial institutions do not have a retail endorsement on their DFSA license because they do not wish to service retail clients because it attracts more risk, or it requires more regulatory governance, whereas onshore they would service those retail clients but subject to the central bank regulatory regime. In any event, the DIFC's regulatory authority takes precedent over the central banks, but only within the DIFC, and it doesn't extend outside of the DIFC into the rest of the UAE. The claimant, interestingly, when the first reaction to the allegation of mis-selling this product was to pursue a complaint with the Central Bank of the United Arab Emirates, and that, to me, is a clear indication. Excuse me?
That was in 2010?
Correct. That was in 2010 when the first issue of the losses under the product and the leverage came up. And that complaint was ultimately dismissed by the central bank.
This is something I don't find it in my paper. I mean, I didn't find any result of that. It's been mentioned, but maybe I didn't find it, or I didn't see it. Maybe somewhere. Just give me a note. Where can I find that?
I see.
The outcome of the investigation.
I see.
They open investigation anyway, or how they
open it, but my understanding is that it wasn't pursued on the basis that it wasn't. The investigation was closed, but there was no reaction or response to it, as far as I'm aware.
So there is no reply from the central bank.
We are not aware of one.
You're not aware. I mean, let's put it this way: the defendant, Standard Chartered Bank, has been asked by the central bank to to reply to the complaint made by the claimant?
There was correspondence with the central bank, but there was no conclusion.
Since 2010?
Not that we are aware, the claimant might be aware. Yes.
Okay.
Yes.
Thank you.
But as far as we're concerned, there's been no further action since 2010, and therefore, I think the assumption is that the central bank did not take that complaint any further.
All right.
I'll next talk about the applicable law that was chosen by the parties. The relevant transactions, the YDA and the various other agreements that went with it, are governed by UAE law, except for the interest rate swap, which is governed by the laws of England and Wales. And I refer to paragraphs 35 and 36 of the witness statement of Robert Loosley, which talks through the various agreements and the provisions which specifically assign UAE law, or in the case of the IRS, English law.
So the English law reference was just for the interest?
Correct.
What as I said. But the rest of it, the rest of the relevant transaction was reference to UAE law?
UAE law.
Okay.
I'm sorry, just to clarify,
yes.
Some of them said Dubai law, some of them said UAE law. That provision of that witness statement talks through exactly what they did. But in any case, none of them had specifically referenced the IFC law.
Yeah, because the dealing was with the Bar Jumain branch. Bar Dubai, sorry.
I don't think it's controversial, and if you'd like me to spend more time on it, I don't think it's controversial that this court can apply laws of other jurisdictions.
No, it's not my point. Just would like to...
No, that was my next point.
of course we can.
Yes, there are numerous cases where this court has applied different laws.
If it is agreed by parties.
Yes, I mean, even the legislation of the DIFC dictates that. In law number 12 of 2004, which is the judicial authority law, it expressly states at Article 6, the court shall apply the centre's laws and regulations except where the parties to the dispute have explicitly agreed that another law shall govern such dispute. That's one. DIFC law number 10 of 2005, relating to the application of DIFC laws, states at Article 9, an express choice of a governing law in a contract shall be effective against all persons affected thereby. And in my skeleton argument, you'll see at paragraph 37(12) and onwards that there are various other provisions that allow for or demonstrate that it's not controversial. And I think Your Honour is with me on that point. Yeah. If the parties had agreed to subject their agreement and their relationship outside of the agreement even to DIFC law, then DIFC law, we would have no dispute, would be applicable to this case. However, the parties did not do that. There is no reference in the agreements to DIFC law being applicable. The claimant's reply to the to the application and our witness statement is at Authorities Bundle 2, tab 13, page 5. And I request respectfully that Your Honour keeps that document handy because there's a couple of points in there about sorry, Authority Bundle 2, sorry, not Authority Bundle, Main Bundle 2, tab 13.
Main bundle, right? Tab 13. Case in bundle 2, right?
Correct, main bundle 2, yes. Tab 13.
Yes.
At page 5,
okay.
at page 5, going over to page 6. Page 6 of the bundle, that is. We'll start at page 5, if you don't mind, at paragraph 1.26. I quote, "About the objection that DIFC law does not apply, the law," which is my submission, "the law is well settled that the defendant is a licensed centre establishment in the DIFC, subject to the jurisdiction of DIFC courts, settled in the Corinth case, and the DIFC court can only apply the DIFC law. There is no other interpretation possible." I humbly submit that that's just incorrect. The case of Standard Chartered Bank versus Investment Group Private Limited, which is at Authorities Bundle 1, tab 19, again, I'll be referring to this case for a few points, so it's worth keeping it open.
Yes.
Is a case which dealt with jurisdiction, which is relied upon by my learned friend. I'll demonstrate that it's directly opposite to what his submission is. But in any event, that is just another case that demonstrates that the court applied UAE law and the laws of England and Wales that were relevant in that claim. The relevant provision of those agreements delegated the applicable law to English law and, I quote, UAE law. And there was no dispute as to whether DIFC law came into it. I just simply can't imagine that legal counsel in that case would have suggested that when the agreement was very clear. The argument was instead about the judicial authority law and whether SEB as a centre establishment should be subject to it. And it is. It was found to be. I've also said before, and I'll just say it again in this context, that there is no physical connection to the DIFC in these transactions either. Now I'd like to just understand, or take Your Honour through the argument as the claimant has put it, relying on Standard Chartered Bank versus IGPL, to just demonstrate how my learned friend has selectively quoted from that case and failed to quote the provision which, in my humble submission, directly contradicts the case and is a Court of Appeal, a judgment of this court. The claimant contends that DIFC court can only apply DIFC law, which I've already spoken about. I think that Your Honour is with me that that's just a wrong submission. The claimant's arguments on this point is worth highlighting just to demonstrate how wrong it is. In its reply, which I think Your Honour has open there, the claimant quotes from that judgment at paragraph 2.62, which is page 20.
Okay, I get lost a bit, so it should be again in bundle 2, right?
Yeah, page 20 of volume 2, yes. Apologies, Your Honour, we should colour code these files, so one's authorities, one's the main bundle.
Yeah, page 20 of the bundle, or point? Referring to point 2.
Yeah.
2.62?
Yes. In this extract from the IGPL's decision, from the Court of Appeal's decision in the IGPL case, the claimant seeks to assert that this quotation justifies the reasoning that DIFC law should always apply to DIFC cases. And if it's worth just reading this to demonstrate how fundamental this point is. It states that where IGPL's argument has taken a leap of logic is in conflating the DIFC substantive regulatory law and the DIFC procedural laws. In our view, and contrary to IGPL's suggestion, there is no necessary connection between the two. A jurisdiction may enact extraterritorial statutes prohibiting certain conduct taking place abroad, even though its court's jurisdiction over an entity fall afoul of those prohibitions turn narrowly on the proper and effective service of that entity. Equally, a jurisdiction may enact regulations within its territory over which cover only activities taking place within its territory, but prescribe jurisdictional rules which permits its courts to hear disputes concerning conduct taking place abroad. No absurdity arises in either scenario. It seems elementary to us that substantive rules and procedural rules operate on different planes, so there is no merit in IGPL's unsubstantiated suggestion that there must be unity between them as regards the territorial scope. Now, it's not entirely clear taken out of context, but my submission is that what the Court of Appeals is saying there is that, yes, you can have jurisdiction over a matter and make that exclusive pursuant to the DIFC's legislation, but that doesn't automatically mean that the DFSA's laws or the DIFC laws apply overseas, onshore, I should say, or in any other country. And that may not be convincing, but I would like to refer you to a paragraph or two before that quote in the case itself. So if Your Honour would turn to Authorities Bundle 1, tab 15, page 117.
Tab 15, page 117. Yeah.
And apologies that this might require a little bit of reading from me. I'll try and do it quickly. But paragraphs 116 and 117 are fundamental to our case as demonstrating what the Court of Appeal thinks about the claimant's argument. In paragraph 116, it states that IGPL contends that the term licensed DIFC establishment must be interpreted consistently with similar references such as centre establishments in Dubai Law Number 9. It submits that the term centre establishment in Dubai Law Number 9 can only refer to a particular branch of in the DIFC and not the entire legal entity. Just so you're aware, the Court obviously held that that's not the case, that one legal entity is a person, whether it's onshore or in the DIFC, for the purposes of jurisdiction. And the quoted section from IGPL's submission, I'd just like to refer you to the final sentence beginning on that footing in that quote that is just in the middle of paragraph 116. And it goes to the argument that IGPL put forward that if the DIFC court holds that centre establishments are subject to its jurisdiction, well, that would mean DIFC laws apply to all branches, and by way of example, it says that DIFC laws would apply to the bank's branches in Almaty, Kazakhstan. And its conclusion is that on that footing, every SEB branch globally would be subject to regulation by the DIFC competent authorities, and the DIFC's express intention to work with the home regulator of foreign recognised companies in the DIFC would be meaningless. The key quote for our case today is at paragraph 117, just below that, and I'll just read that. The Court of Appeals said, "It is plain from the highlighted section of the extract above that IGPL's argument is circular and must therefore be rejected. In our view, interpreting centre establishments to mean the whole legal entity of a company operating in the DIFC does no violence to the language of Article 9 and 10 of Law Number 9, Dubai Law Number 9. neither would it mean, contrary to what IGPL contends, that the activity of SEB's non-DIFC branches would be curtailed by DIFC regulations, since the DIFC's regulations only apply to activities taking place in or having an effect on the DIFC. For example, Markets Law DIFC number 1 of 2012 expressly states that its provisions apply only in the jurisdiction of the Dubai International Financial Centre, and the general prohibition imposed by Article 11 against the making of security offers is confined to those made to the public in or from the DIFC. Once it is appreciated that the DIFC's regulations are not extraterritorial in their scope, it becomes clear that the scenario posited by IGPL can only be described as fanciful. Essentially, the Court of Appeal has a premonition of my learned friend's case and has dismissed it with that simple statement. It is helpful that the Court of Appeal uses the word fanciful as the last word in that paragraph, on the basis that the English Court of Appeal, when considering when summary judgment should be given, and I refer to paragraph 44 of my skeleton here, in the case of Swain versus Hillman, states that with respect to a summary judgment, a respondent to an application needs a case that has a real, as distinct from fanciful, prospect of success. The Three Rivers case, which is again referred to in paragraph 44 of our skeleton, the House of Lords stated in paragraph 95 that for a case to be fanciful, it must be entirely without substance, and where it is clear beyond question that the statement of case is contradicted by all other documents or other material on which it is based. The fact that the Court of Appeal has already decided that the argument that this court can only apply DIFC law is a fanciful argument means that my job today is made a bit easier. My submission is that proposition by the Court of Appeal and the fact that DIFC law is not applicable to the case is completely dispositive of this claim, and therefore this immediate judgment should be granted.
Okay.
If Your Honour is persuaded that somehow that position should be overridden, and that my learned friend's arguments that DIFC laws, the very many DIFC laws that have been referenced, should apply to this dispute, then the alternative argument, should that be the case, is that the vast majority of the bases of the claims are time-barred. And for that, I'd refer to paragraphs, starting paragraph 46 of our skeleton argument. Now, forgive me, Your Honour, because it gets a little technical, because each provision of the DIFC law that has been claimed varies its time bar and the way it expresses it. But I'll refer to paragraph 48 because it might be easier to follow if we refer to the wording. The claim that's made under Article 94 of the regulatory law states that a proceeding must not be commenced more than 6 years after the dates of the events. So regulatory law, 6 years. Restitution under Article 48 of the Law of Damages is 6 years from when the action accrued. Subparagraph 3, claim for fraud under the DIFC contract law, 6 years from when the aggrieved party becomes aware of the fraud. The references are all there. Claim for misrepresentation under Article 29 of the DIFC Law of Obligations states that where a cause of action arises as a result of fraud, and we'll come on to whether that's been pleaded, But where the allegation, cause of action arises as a result of fraud, there is no time limit for which the action must be commenced. If fraud is not alleged, and it's simple misrepresentation, then the cause of action arises on the earliest date on which the claimant knows or ought to have reasonably known about the loss that gives rise to the action, provided that any action is brought within 15 years. So essentially we've got 6 years for most of the claims, but then 15 or no time limit for the claims for fraudulent misrepresentation or misrepresentation. Just turning to when the cause of action accrued and how that's applied to this case. We accept, firstly, that the final grounds are not time-barred, but they should be dismissed on various other grounds. But the other claims under the contract law, under regulatory law, law of damages, and contract law should fall away because they were brought 6 years after the 6-year time period. The claim under the regulatory law, the law of damages, was commenced after 6 years of the events that gave rise to the claim. We submit that the action accrued on the 15th of May, excuse me.
2009.
Yes. 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 13th of January 2009, when the stock trading limit was triggered, is potentially the date at which the action accrued. In paragraph 52 of our skeleton, I've referred to a case called Bhatia versus ICICI Bank Limited, 2014 DIFC CFI 018. And that's an important case because Mr. Justice Giles considered what limitation means under DIFC laws. And he supported the analysis that was given in Australian courts. I refer to Authorities Bundle 1, tab 16, page 136, paragraph 28.
Authority Bundle.
Authority Bundle, correct. That's volume 1, tab 16.
Tab 16, then page
136.
136. Yes. Paragraph
28.
Yes.
Excuse me, paragraphs 23 and then 28.
Mm-hmm.
And it's quite long, those passages, so I'll allow Your Honour to read them.
No, make your point.
Yeah, okay. Well, so essentially what those provisions state is that the key quote might be helpful for me to just highlight in paragraph 28, which starts with the sentence, "The matter may arise." And it says, "The matter may arise in the course of proceedings, and it being necessary to express a final view for the purpose of the application, it is preferable that I do not do so, but I doubt that there is a correct analysis." And that's just to say that it's not necessary to make this finding, but he's making comments on limitation periods anyway. This case was to do with the loss suffered on the purchase of shares. It states the shares were taken up in January 2008, may have been worth what the claimant paid, his investment being subject to a contingent loss suffered only when the contingency of the forfeiture was fulfilled. There may be causation issue here, but that is another matter. I do not think it can be found at this interlocutory stage of the proceedings that the claim is statute barred. So the essential point there is that what Mr. Justice Giles does there is refer to when the loss accrued, and in our submission it has to be when the claimant realised that it's not going to get its $3 million back. And I'll just talk you through that, the reasoning for that as applied to this case. The claimant's case arises from allegations that he had suffered loss by having entered into an investment which is worth less than he thought it should be. And that is in dispute, and if this matter does proceed to trial, that will be tested. The claimant also contends that on various representations that were made by the defendant, it was entitled to receive 100% not just of the investment, but of the loan amount as well, so it's $3 million back. In another Court of Appeal case of the English courts, Shaw versus Sedgwick Financial Services, it's referenced at paragraph 53 of my skeleton. The Court of Appeal held that the claimant had suffered loss when they had obtained the bundle of rights which were less advantageous to the claimant than they expected. So what that would be interpreted as is at the date of purchase of the YDA is when the rights accrued, and that should be the time that runs from. If that is the case, then the claim under the regulatory law and the law of damages would be time barred, because it's clearly 15th of May 2008 is clearly more than 6 years ago. In the alternative, if the claimant suffered the loss with respect to the YDA on the 13th of January 2009, he subsequently decided to unwind the product on the 10th of February, and on the 18th of February the product was unwound. That's all in 2009. When the stock trading limit was reached, it was not possible at that point to achieve any return on the YDA. So essentially, if we look at February 2009, that's when it's obvious to the claimant that it has lost money and it's looking for someone to blame for that. And it happens to be Standard Chartered Bank in this case. That point was again more than 6 years ago. So on any interpretation of the case law, the claims under the regulatory law and the other claim under the law of damages as well as the law of contract must pay. Both dates, either 2008 or 2009, are outside of the 6-year period. The claim under Article 40 of the contract law is with respect to the allegation of fraudulent misrepresentation.
Just before we move
Yes.
to the point, in 2009, was there any kind of notification from the defendant to the claimant about their position in this transaction? Or?
There were many correspondences and discussions between the parties about what to do now that the stock trading limit had hit. But there was no resolution. The dispute that we have on the facts, if this ever had gone to trial, would have been about whether the bank had owed some sort of duty to the claimant to advise it differently, or whether it gave it the right advice or it didn't, if there was that relationship. There are a whole host of questions, but it's very, very clear that at that time this decision was made by the claimant. Now, the claimant will say, you made me do it, you being the bank, and I was being advised and I relied on you and you caused me this great loss, leaving aside the fact that the financial crisis had happened by that point.
Well, again, so what I'm looking for here, kind of a formal communication in terms of like a letter from the bank to the client saying, this is your position in 2009, you lost your investment, this is the outcome of the situation. So this is what sort of document I'm looking
understand.
for. Unless there is just an email.
I think we do have a correspondence which finalises the loss and what happened, and I will hope to find that.
Do we have it in this bundles?
It might be, but if I can perhaps come back to you in a few minutes.
Okay.
Thank you. In any event, I don't think it's
before you move to the mispresentation and the fraud.
I see.
We need to cover that one.
Okay.
Maybe they can give it to me later on.
Yes, exactly. Okay. I will make sure we come back to you on The claim under Article 40 of the DIFC law, in respect of that, the claimant became aware of what it alleges was a fraudulent situation on the 18th of January 2009 when the stock trading limit hit and was communicated to the claimant. The date of accrual of the claim under Article 40 is therefore 18th of January 2009 in our submission. And again, that's outside of the 6-year period. And I'll explain why that 2009 is the key date there. Article 123 of the DIFC contract law requires that a aggrieved party be aware of the fraud, and that's a quotation from Article 123, aware of the fraud before the limitation begins to run.
Yes.
In English law under Section 14A of the Limitation Act, states that the time to bring the claim starts from when the claimant has both the knowledge required for bringing the action for damages in respect of the relevant damage and the right to bring such action. That, I think, just amplifies the fact that the time runs from when the claimant is aware of fraud.
Which law now we are following, the English or the DIC?
Excuse me?
Which law now we are following, the DIC or the
well, it's the DIC law, but it's commented on, the principle is commented on in English law, but essentially it's Article 123 of the DIC contract law. The English law reference was just to amplify the point.
Now, if you go to the first argument about your position to apply the English law on some of those transactions, what is the time bar of the English law? Is it 6 years as well?
6 years, correct.
Yeah?
Yeah.
Okay.
Yeah, sorry. Under English law for fraud, it's 3 years.
No, that's not a fraud.
Yeah, for contract
So
claim,
that's
6
not
years.
yes. Okay.
So, in respect of this allegation, it would be apparent from the claimant that the YDA and related investments had been missold to the claimant when the stock trading limit had been triggered on the 13th of January. There's nothing the claimant knows now or later that it didn't know on the 13th of January with respect to the situation. The claimant at that date had made a loss, and it must have then realised, I was missold this product. I thought I would be getting at least 3 million back, and now it turns out I'm getting a lot less. The allegation or the idea that someone had defrauded him or misrepresented to him would have been apparent then, if not on the day, maybe the day after or a few weeks later. Yes, okay. The document, actually, I'll kill 2 birds with 1 stone here. The document which informs the claimant of the situation with respect to his investment is Application Bundle 1, Tab 12.
it the letter of complaint to the central bank you're looking for?
No, if you look at page 303 of tab 12, and when I say 303, it's the bottom, most bottom number. This is a communication. If you look at the first email at the bottom of the page, in 2008, April, from Peter Newman to Mr. BJ.
We're looking for which email?
Excuse me?
Which email we're looking for?
So it's the, on page 303, the bottom half of the page is an email from Peter Newman to Mr. Ideas. But note that that's in 2008.
2008.
If I may, Your Honour, the only reason I highlight that is just to demonstrate that even in April 2008 there were discussions about the scenario analysis, what might happen if, you know, US dollar gains or loses and that kind of thing. And if you turn over the next page, you'll see that there is a scenario analysis provided to the client.
Yeah, but this email suggests the claimant now should be aware that he lost his investment.
Well, that's the email on top. So just above that email, on January the 18th, 2009, and it's worth me just very quickly reading this for the purposes of... It says, Dear Bijit, we refer to the investment in the YDA. Due to extreme volatility witnessed in the market in the recent past, we regret to inform you that the strategy was stopped out in order to protect the principal. The implication is that while the notional principal will remain protected, it will not be exposed to the strategy anymore. So that's really referring just to the YDA product. Then it says, as in the past, the floating leg of the interest rate swap will pay USD LIBOR into your account, matching the debit against the 2 million loan during this period. The corresponding debit on the account of the fixed leg of the swap will happen at the end of the investment period. We have attached a scenario analysis provided to you in April highlighting the position of the investment. I and Kuma look forward to speaking to you at a convenient time. And then there's a memo attached. So essentially, there is an argument, obviously, about whether that communication attracts any liability or did it advise the claimant to do something which made it suffer some sort of loss. But that's not the point for which I highlight it. The only point I highlight that letter is email is to respond to your request that for a letter which establishes, right, this is what's happened, this is your loss.
So what we have only emails, we don't have any official letter from the bank to the client.
Yeah, well, if you look on the third page after that email, page 305,
yes,
there is an official Standard Chartered publication which demonstrates the performance of that YDA update, which was attached to the email. But my submission is that email or letter are the same in this context.
yes.
Because that's the way by which the parties communicated with each other, and there is no suggestion from the claimant that that's not a valid way of discussing the performance of the investment.
Okay.
In any event, I think my submission is that at least by 18th of January, the claimant would have realised that they have suffered this loss, and if they are thinking, well, that was not my expectation, and I would blame Standard Chartered Bank for having entered me into this arrangement, they would have known that on the 18th of January 2009.
Okay.
In fact, the investigations into the matter ultimately resulted in a complaint to the central bank in July 2010 requesting an investigation into the YDA.
Mm-hmm.
And so at least by 2010, the claimant has thought about its position and said, I'm not happy about this. I think a wrong has been committed to me, and I'm going to make a complaint about it rightly to the central bank, not, I note, to the DIFC court.
Okay.
At paragraph 2 of the reply to the application,
We should go back to what was the button?
it's application bundle volume 2,
Yes.
tab 13,
Yes.
paragraph 2. Apologies, Your Honor, I'm just finding the specific reference to the accrual. I will find the spot, but essentially the claimant suggests that 10th of July 2013 is the date at which it ultimately realised that there was a claim, and our submission is that's too convenient, because what that does is bring the case within 6 months.
Yeah, but
There is no other basis for.
what happened in that day? I mean, in that year, 2013. I mean,
That was a date that the defendant sent a letter notifying the claimant that it was that the defendant was exercising its right of set-off with respect to the investment.
yes.
So essentially, it's part of the transaction, which I won't go into detail here, but it was just the next step. Now, I'm fully conscious that the claimant has got many complaints against the defendant. This is part of the transactional framework that set-off occurred against what was owed under the loan
Yes.
and the fixed deposit.
And that took place in 2013.
Correct.
Why not before? Why wasn't it 2009 or 10?
Yes, that was the date that the interest rate swap expired. It was a 5-year interest rate swap.
Yes.
The claimant chose to keep the interest rate swap in place.
Right.
And it's paragraph 2.70, 2.70, page 20 of the reply. Sorry, 22 of the reply, which talks about 2013 being the accrual date.
So what we are looking for here is, my understanding in 2013, somewhere in May, the 23rd of May, or I forget the date, when the defendant make that deduction, if you like, the 700 something US dollar. Just correct me if I'm.
That is correct, yeah.
And
It was around that time when the IRS expired.
Does the claimant, he know about that earlier, or only he know that about the deduction, about his loss of 700?
It
on the
would
same-
have been obvious in that analysis.
Correct.
Yes, so in the complaint to the central bank
Yes.
in 2010, it was very clear that the claimant understood what his potential losses might be.
Did he mention
said
that? Did he mention that?
He did, and I'll refer you to the letter.
Did the letter mention the 700 loss?
Yes,
Precisely the 700? Yeah.
I'll refer you to the
I think
letter.
page 313
You may have got that before us.
should be in page 83 to be specific.
Apologies, you're much faster than us today.
Not just.
Okay. So, on page 312, which I think you have, is the letter, very detailed letter of complaint. And I'm sure Your Honour would like to read that.
No, I found what I'm looking for.
Okay, thank you.
Page 313, the paragraph to be started to be specific and mention the $700 loss.
Correct.
Okay.
I won't say more about this, but obviously a claim under Article 40 is 6-year time barred and from awareness, and the claimant, it just cannot be denied on the evidence that's here that it was not fully aware of the circumstances of the claim when it made that complaint in at least 2010, if not before.
Right.
And again, July 2010 is outside the 6-year limitation period.
Okay. Now you move to the misrepresentation.
Correct. Thank you. So the next claim is under Article 9 of the DIFC Law of Obligations, and under that provision, which is for claims of fraud, for misrepresentation, excuse me, under Article 29 of the DIFC Law of Obligations, excuse me,
Yes.
Where there is a claim that is alleged to be as the result of fraud, yes, thankful to my colleague, for fraudulent misrepresentation, the relevant period is 15 years. Unlimited. I'm confusing myself.
Yes.
And for claims in misrepresentation is unlimited. That's 15 years.
No,
My apologies, I'm confusing myself. But if I refer to paragraph 62 of my skeleton, I've said it much better than I've just stated it now. My submission, Your Honour, is that these allegations that allege misrepresentation under the law of obligations were conveniently put into the claimant's amended particulars of claim simply to allow this claim to artificially fall within a non-time bar or within time. And I'll demonstrate why that should not be permitted in a second.
not permitted the amendment article of claim or?
The amended particulars of claim, correct. The particulars of claim did very, very vaguely refer to misrepresentation and fraud.
Yes, he got the permission to amend the particular claim.
Yes, and we didn't dispute that ultimately.
Yeah.
But the submission in respect of that is that it's clearly with an intention to bring the claim within time limits in that respect. That, if there was a claim that's been substantiated and put forward, that would be fine. But my submission is that the claim in misrepresentation should be struck out for the following reasons. I may just remind Your Honour at this stage that this is all in the alternative. Our fundamental position is that DIFC law doesn't apply. We're just assuming for a second it does apply. Rule 1743 of the DIFC Court Rulebook, the DIFC Court Rules, requires that a party should specifically set out matters in their statement of case that they wish to rely on in support of their case and provide full details of any allegation of fraud or misrepresentation.
In the statement of case.
Correct. We submit that the amended particulars of claim do not properly specify or provide any detail of alleged fraud or misrepresentation under the DIFC Law of Obligations and the DIFC Contract Law. And therefore the claim should be struck out. Before I refer to where in the amended particulars the allegations are raised. I think that's important to do, just so you can see how basic the proposition has been. I refer Your Honour to a case named Amjad Hafiz versus Damak Park Towers Limited, which was referred to in paragraph 66 of my skeleton. Again, Mr. Justice Roger Giles struck out the particulars of claim containing allegations of fraud. He held that, at paragraph 9, I quote, "The particulars of claims deficiency is more fundamental than an absence of requisite details. The case to be made is wholly obscure." In that case, it was not clear which statements and representations in the particulars were said to have been fraudulent, or whether representations were fraudulent because they were known to be false or because they were reckless as to their correctness. There was frankly no articulation of it. And it's practice, at least, if not written anywhere, that when you're alleging dishonesty or fraud or any sort of wrongdoing on that level, there must be sufficient detail to be able to respond to it in your claim. Otherwise, it must be struck out. Mr. Justice Giles set out that it's necessary to make one's pleading with precision how the representations were made that are allegedly fraudulent and what made them false or deceitful. That's paragraph 14 of that judgment. Turning to the amended particulars of claims, our submission is that the claimant wholly fails to allege which representations of the defendant were false or fraudulent, or whether the representations were fraudulent because they were known to be false, etc., etc. There is no detail whatsoever with respect to the claim for fraud attributable to the alleged misrepresentations under Article 929 of the DIFC Law of Obligations. Now, if you don't mind a little bit more time, just to refer to the amended particulars of claim to show you what is said about these allegations of misrep and fraudulent misrep. I refer to the amended particulars, which are at Main Bundle 1, Tab 9, and that's page 164 it starts. So what I'll do now is very quickly take you through each reference to these allegations that the claimant has made. And there's 4 of them, so it won't take long, to demonstrate how the claim has been articulated. So the first is in paragraph 5.3, and that's on page 181 of the bundle. The claimant here quotes Article 94.1 of the DIFC Regulatory Law, which contains the word fraud or other dishonest conduct at paragraph B.
Yes.
Notably, the emphasis is on other dishonest conduct rather than fraud, so arguably it doesn't serve any purpose. But in any event, there is no other explanation as to why this claim should be based on fraud in respect of that provision, at least. It just simply quotes the law. Frankly, that's not sufficient for Mr. Justice Giles' test. Paragraph 5.11, which is on page 183, the claimant refers to Article 40 of the DIFC contract law, which he alleges entitles the claimant to avoid the contract and seek restitution. The claimant refers to Article 40 in a footnote, which refers to fraudulent representation. No further details are given as to why this claim is one under that provision. Paragraph 5.61 on page 199. Apologies, beginning 198.
Five point.
5.61. The claimant here says that the wrong advice was given to the company to unwind the investments, and that this amounted to fraud, misrepresentation, breach of trust, and unjust enrichment on the part of the defendant. In this paragraph, the claimant lumps the allegations together as to the allegation of fraud. It is frankly not at the standard required to make that allegation in accordance with Mr. Justice Giles's test. In fact, I would submit that the allegations of fraud in that case, the Damak case, were much more detailed than this one. Finally, paragraph 6.15 on page 209. This is not a separate round of relief, it's just summarising the relief. And there's a reference to fraud under Article 40, and it requests a declaration to be read together with Article 94. Again, no further explanation, and frankly, it would be very difficult for the defendant to respond to those allegations in this way. Those are the references to those allegations from the amended particulars of code. So far, and I apologise because I've run over by about 25 minutes, but I'll try and finish this last bit, unless Your Honour suggests a break. So
I'll take a break after you finish.
Thank you. So far, my primary submission is that DIFC law doesn't apply, and therefore there's no cause of action. If that fails, then all of the claims are time-barred except for the allegations that we've just outlined in misrepresentation and fraud. But those claims should be struck out for lack of particularisation in accordance with the Damak case. That demonstrates that there is no reasonable prospect of success in this case. The first limb on its own, but if that fails, the second limb. There is a second aspect to the test for summary judgment in Part 24, which is that there must be no other compelling reason for why the case should go to trial. Apologies. The immediate judgment should be refused if Your Honour considers there to be some other reason why this should go to trial. The issues before you today are clear points of law. One is the applicability of DIFC law to the jurisdiction here, to activities outside of the DIFC, and the other is with respect to interpretation of time bar provisions, if that first argument fails. If Your Honour is not prepared to accept this application, your finding would really be that DIFC law is applicable to this dispute. That would have to be the conclusion. result of that is that we will proceed to trial, provided that there's no appeal and that decision stays. We proceed to trial, and we will have exactly the same debate that we are having today. And the reason for that is that there's no evidence required for this debate that we're having today. It's simply a question of the applicability of DIFC law here or not. So it doesn't require the rigour of a trial. It doesn't require witness evidence or disclosure or anything else. I don't think there's been any complaint about not having enough to argue whether DIFC law applies here or not. It's based on Corinth and IGPL and other cases as far as my learned friend is concerned. Ultimately, there'll be no witness evidence to decide that point. The only witness evidence that might be relevant is only if the claimant suggested that, well, we met in DIFC's offices, SEV's DIFC office, or we had a coffee at one of the cafes here to sign the deal. Even on that basis, that doesn't mean DIFC law applies. It might do, but I don't think it does, because the claimants and the defendants decided to apply a different law. But if that was the case, you might need witness evidence to say, yes, I arrived at DIFC by taxi on the morning, I walked to this cafe and I went to the SEV's offices. It's not in contention. There was no link to the DIFC. The claimant suggests in his skeleton that the case would just be this would be a mini trial of important issues. I think one day to decide these two important legal questions is more than enough. The question of time bar equally is a legal question and doesn't require any sort of trial. The claimant has sought to suggest that the disagreements between the parties in relation to the facts and the fact of the claim for fraud and misrepresentation requires that this case proceed to trial and that witness evidence is put forward. And that's correct. Often claims for fraud and misrepresentation do require detailed analysis and high degree of proof. However, that investigation with disclosure and witness evidence is required where the claimant's claim is entirely based under applicable laws. The fact is that these laws of fraud and misrepresentation that are quoted are just not applicable, as my first argument demonstrated. You'll be very happy to hear I've just one concluding comment to make, which is that the claimant has brought the entire claim under the DIFC law. It could have not brought the claim under DIFC law, but brought it under UAE law, which is what the contract states, or in English law. It had many opportunities to do so at various stages. In fact, an amended particulars of claim was filed and accepted, and that's where it could have put its amended claim. It would be an abusive process now to allow the claimant to come up with some other basis, but it is very clear that it's stuck to its position that DIFC law should be applicable, and it's done so on the basis that this court has jurisdiction, which is two different topics entirely. For those reasons, my submission, Your Honour, is that the claimant's claim has no reasonable prospect of success and that there is no other compelling reason for proceeding to trial. May I have one moment?
Sure.
Your Honour, if I may just have your attention for 1 or 2 more minutes to deal with 2 points that came up. The first is in relation to whether we should have filed an amended defence. And we have a transcript from the wonders of technology has allowed me to pull up, my colleague at least, to pull up a transcript of the hearing. which we can send to the registry by email as well, but I'll just read it out here to demonstrate that there was no need for a defence. I said in that hearing the following: the amendments to the particulars of claim are already on the record. The defendant does not need to file an amended defence in order for the immediate judgment application to take place. We have enough on the record to be able to bring the immediate judgment application and for it to be heard. The point we would make there, if the immediate judgment application fails, that's the point at which we would be given time to amend the defence so that the case can carry on. The point on that is that whilst we may respond to the amended particulars, it might be irrelevant because our immediate judgment application would be successful. And the judicial officer, His Honour Nasser Al-Nasser, replied, okay. And my response was thank you. That's just from the transcript, and I think that was the understanding upon which the order was issued. The second and thankfully final point is that I have confirmation from my client that compliance within the bank has confirmed that when a complaint is made to the central bank and it's investigated, no further action means that the complaint has been dismissed. That's the practice of the central bank, as we understand.
If you've got that in writing, I mean, there is no further action, or verbally, or?
No, but there wouldn't be any action. I think the point is that the central bank's silence demonstrates that there's nothing.
And this is a practice?
Sorry?
Is that a practice? To be silent?
It's historically, not anymore, I think.
Okay,
but at the time.
We'll find out from the claimant.
Yes, I'm sure we will. But 8 years later, there's been no further action.
Okay. All right. I think.
Thank you. Thank you for your patience.
Appreciate it. So, would you mind to take a break for 5 to 10 minutes and come back to you and to hear from you until 1 o'clock or 1:30?
Sure, Your Honor. Your Honor, with your permission, I just want to highlight 2 important facts before we go for the break, if it's possible.
If we're going for break, then there is no advantage to hear from you. So just take a break for 5 to 10 minutes, just to refresh again, come back to you, and we have the full time to hear from you and get the point. All right? So 10 minutes break.
All right.
Thank you.
Yeah. We watched a YouTube video and we typed out that section.
So we can send you the link to the YouTube minutes.
And we can send you that on transcript. Yeah. Yeah, we've got the we've got the minutes where it was said on the YouTube video. Yeah. So that comes from there. Would you be able to give the email?
Which is
Yeah, he's got the codes. Okay.
said it's not the right way. Just see like this.
Okay.
With your permission, Your Honor, I'm representing, I'm the counsel for the claimant in the instant proceedings. Your Honor, since this Honorable Court has gone through these documents which are before the court in extensive detail, so I will adopt a slightly different approach. I would not like to read my skeleton on the understanding that this Honorable Court had an opportunity to review most of its points. The strategy that I would like to follow in my submission is to try and rebut most of the points that were raised before this Honorable Court. But before I do that, I seek the permission of this Court to bring to the attention of this Court three critical points which are relevant to this case. Now, this application, Your Honor, which is before this Court, pertains to an application for an immediate judgment. Now, clearly, the requirements of RDC 24 need to be satisfied, but at the very outset, I would like to say two things. All I need to show to this Honorable Court, to rather demonstrate to this Honorable Court, is that my claim is not fanciful. In other words, there is some merit in it. It may not be the most meritorious claim in the eyes of my learned colleague, but it has some merit in it. In other words, it is an arguable matter. In other words, there are issues to be framed and to be decided by the court that need to be adjudicated upon. Now, Your Honor, with this backdrop, it is very important to look into how this case has come before the court. When we had a case management conference, I don't want to repeat those points because they're already on record. There was an application that came to us on the eve of this conference, and that was this application for an immediate judgment. Your Honor, at the time when they submitted their defense, exactly 50 days later, and we have written this in our submission as well, there was a communication from them addressed to us which said, we intend to file it was I think 13th or something, intend to file our immediate judgment application. And sometime on 29th, they filed their immediate judgment application. Now, what has that to do?
So the intention was to file objection to jurisdiction or to...
No, Your Honor. I just want to highlight...
Yeah, just because I've seen somewhere when they say they withdraw the attention for filing the objection on jurisdiction, they would then that's been withdrawn or something.
I will...
Just to...
Yes, Your Honor. Your
Honor, intention was for the immediate judgment or was for the jurisdiction?
No, they said that they want to file for immediate judgment.
That was what?
On the basis of that DFC law does not apply, and on the basis of the jurisdiction and other things. So this was the, but Your Honor, the point is that they took their, anyway, on the eve of this conference, we received this bundle. Before this case management conference, the issue that was raised, and this is before, if you see the recording of the proceedings, this is also, all the evidence is there on the record. The issue that I raised before the court was that these two grounds, now when you say issue of limitation, now issue of limitation, how will you determine limitation? You determine limitation based on facts, based on when did the claimant first know about it. So there are facts in issue. So limitation is a question of law. It is also a question of fact. So it's a mixed question of law and fact. Now, clearly this issue could have been discussed more appropriately in a trial. Then second point there is was the DIFC, whether DIFC law applies. Now, with all due respect to my learned counsel, we have the law on this issue has been settled by Corinth, and the law on this issue has been reiterated in IGPA case. Now, the only thing that I would do today is take you through those provisions and to show and to demonstrate to this Honorable Court the correct interpretation of these two laws. And Your Honor, another very interesting point where I want to make these few preliminary observations. Yes. Your Honor may have noticed towards the end of the submission, my learned counsel referred to my amended statement of defense. So, my amended statement of case. In other words, my learned counsel had the benefit of going through my amended statement of case, bringing to the attention of this Honorable Court provisions in my amended statement of case without submitting its own statement or amended statement of defense and without giving me an opportunity to give my comments on that. So clearly this court cannot take into account what they have. If they were in a position to make these submissions before this Honorable Court, they were also in a position to file their amended statement of defense. But Your Honor, let's see what happens. Assuming for the sake of an argument that they had filed their amended statement of defense, what would be its legal effect? The legal effect would be the application for immediate judgment would become redundant, because now those issues, once the defendant also files the amended statement of defense, which means issues have to be framed, case will proceed to trial. So they were very clear in this thing that they didn't want to file this amended statement of defense. Now let's look into the order. They showed a transcript to this Honorable Court, and they said, the judge said, okay, where is the order of the judge? Where is the order? The judge passed a CMC order on 1st of March 2000 of this year, 1st February 2018.
Yes.
In that CMC order, judge did not say, I stay the proceedings, because they made a request that until this application is decided, we should stay the proceedings. The judge did not make it in that order of the CMC order. The judge also did not say, the judge said you are required to file your amended statement of defense.
Now, can you take me to this CMC order and
yes,
my understanding towards permission?
Yes, Your Honor.
So the permission means whether they can do it or they cannot do it. This after. Can we go again to this?
Yes, Your Honor.
I found it before somewhere, but I cannot remember where.
Volume 1, tab 10.
Okay, bundle 1, huh? Application bundle 1?
Yeah, application bundle 1,
Yes.
tab 10,
Okay, that
page. No, it's consent.
yeah, shall be allowed to.
Page 212.
We're looking for page number 212.
Yes, yes, Your Honor.
Yeah, the defendant shall be allowed to amend. Right?
Yes, Your Honor. It says defendant shall be allowed to amend their defense pursuant to the claimant's amendments, and the defendant shall be treated as a heavy application.
Yeah, my reading from point 2 is this is for the defendant to decide whether they want to amend or they don't want to amend.
Your Honor, absolutely clear.
Right.
That is exactly my point, Your Honor. This is the point I was coming to.
Now your point saying that the defendant have to.
No, Your Honor. I stand, if I make that, I'm so grateful to the Honorable Court for correcting me on this issue. Because what I have argued in my submission, Your Honor, if you would have, as you may have gone through my submissions, it is not, they are not bound to submit, Your Honor, their amended statement of defense.
Yes.
Now in law, when the court gives you the permission, now it is expected that you would do so within a reasonable time. You cannot unilaterally, Your Honor, make a determination that unless and until my application is heard and decided, then I will file my amended statement of defense. Now, when they do not file their amended statement of defense before this hearing, there are two things that can happen. One, they have lost or waived their right, as I have pleaded in my reply, to file this amended statement of defense. This could be one. This is one possible logical conclusion that one can arrive at. And second, they cannot ask this court, they are not assisting the court, this will not assist the court in establishing the facts. In other words, they make an incomplete application. Now I'm happy with that. I have no objections that they have not filed an amended statement. So I'm not saying that they have to. They may choose not to. Yeah. But if they choose not to,
for the time being,
the legal effect is that they have lost the right because they cannot hold on to this right for an indefinite period. It is unknown in law.
Well, this is for the court to decide.
This is for the, of course, this is the court to decide. But as a counsel, Your Honor, I have to bring to the attention of the court the legal implication as I understand from the perspective of my client's right, Your Honor.
Okay.
Now, Your Honor, They did not file this. Had they filed this, the situation may have dramatically changed. If you, the issue would have been, there would have been tribal issues. I would have submitted my reply. The court has to go through a voluminous detail. Your Honor, second important point that I want to bring to the attention of this Honorable Court.
So before to move to the second point, my understanding from your point, the first point, for the defendant not submitting their amendment statement of defense, that there are certain facts they don't want to explore right now for the purpose for the default judgment. And this is, you are saying they didn't submit their defense, they decided not to submit amendment for their defense because there are certain facts in their defense they don't want to bring it to the attention to the court or disclose right now before the court dealing with the application for default judgment.
Your Honor,
this is my understanding.
Yes, Your Honor, this could be one of the reasons.
Then we can move to the second point.
Your Honor, this is definitely one of the reasons.
But this is the only link you're making between the electoral.
But there is one more link I'm making, Your Honor. Had they submitted, my second point is, had they submitted this amended statement of defense, I would have got an opportunity today to reply to know what their stand is. I have a right as a claimant to know what their amended statement of defense is. Now, if they have moved an application for immediate judgment before the court, what is the effect of this immediate judgment application? This Honorable Court can decide that this case is not, this is where the case should end. So my case can stop today, right before this court, because if this court makes a determination in this regard. So I did not get the benefit of seeing what their defense is. I did not get the benefit of replying to their defense. So you are right, the first point that this Honorable Court has said, this is one of the aspects. And the second aspect is, had they submitted their statement of defense, the case would definitely be a triable case. So they did not do that because of that reason as well.
My understanding, they filed the immediate judgment application before the court decide allowing them to submit amendment of defense. So they submit that application for default judgment on the eve of CMC, I don't understand that, but that come before the court decide to give permission both sides to amend their statement of case. So this is something they decide to do before even the idea came from the court to give them permission. Anyway, I'm just analyzing the...
No, Your Honor is absolutely right. And Your Honor, this is an important point to take note of at least, because this...
Which could be in their favor, anyway.
And Your Honor, another important point, just along these lines that I want to just highlight before this Honorable Court is.
Right.
In the CNC, we have those forms where we give the information of what information we need. We had requested them, their witnesses should come and testify before this court. They gave the name of Mr. Adam Padamsi that they will provide his witness statement. Then there was a second witness but they did not provide his name. Subsequently, they wrote to us and said, this is the second witness who will testify. My question is this, and Your Honor may have seen the pleadings. I'm not pleading mere allegation of fraud or misrepresentation alone. I'm not saying that I suffered this loss and that's why I have filed this case. If it was so simple, I would not have come before this Honorable Court. The issue is that when I submitted my witness statement along with my statement of case, Your Honor, they submitted their defense. If you read the defense which the defendants have filed, they have not even once made a reference to any of the points that we pleaded in our witness statement. Why? Because, Your Honor, in our witness statement, with specificity, I will demonstrate to you, we pleaded that this is how I was induced. And I'm going to go into only the brief points, unless Your Honor wants me to go into it. I will go into it. But, Your Honor, the point is that they did not address, the court should take note of this point, that they did not even address the witness statement that we filed. They did not even say, we filed 2 witness statements. In their defense, they only refer to the statement of case. They do not even say for once that we say Mr. Adam Padamsi induced me to withdraw my money from my investment from this deposit and put it in a fixed deposit scheme. Now this is based on what happened. Now they did not file the witness statement of Mr. Adam Padamsi to either support or contradict what I am saying. They said at this stage we are not required in the defense to file any witness statement. We are not required to give any evidence. Now, Your Honor, the entire case hinges on the fact that, and Your Honor just saw when you asked them to highlight where is the communication, where is the correspondence. There is literally no correspondence. And I have got at least 30 to 40 lectures or emails to demonstrate to this court, Your Honor, where I can take you through one by one and show you what my clients have written to them asking for information, rather begging for information, not once but on a day-to-day basis. So I am reminded of the court of first instance in Bank Sarasin case, where two observations, and I'll take you through those two relevant observations. They said we are influenced to see that there was no communication between the parties. The only communication was a phone call. The person meets and does not give any information. Your Honor, even when the money, when they asked me that you have to, suppose they say that I chose to take my money out of this thing and put it in a fixed deposit, I will show you one provision in the rules which says that even the bank must agree. They did not give me any written communication in this regard. Why this case is suspicious, Your Honor, at this time I don't want to go into the merits, but I want to raise doubts that why this case has to be looked into, why there are tribal issues in these cases, because there is no written communication between the parties. This fact itself stands testimony to the fact that these are suspicious circumstances. So there are only two things. Either what we have submitted in our witness statement, either that is correct, if not contradicted by them. They had an opportunity, Your Honor, in their defense to say what we said is wrong. And when I make specific allegations against an employee of the defendant, then the defendant's employee, who is in their present engagement, must come forward and say what they're saying is wrong. This is absolutely wrong. It never happened. They did not, that person who is in an active employment against whom we have those extensive allegations did not come forward. They said in the defense, we are not required to file at this stage the witness statement. Now, Your Honor, just drawing an analogy on this issue, let's look into I was talking about the witness statement, the testimony of these people. Your Honor, if this application was to be heard today, immediate judgment application, Your Honor wants to know today whether what I have pleaded in my witness statement, is it right or is it wrong? Now, if Your Honor can only establish facts in this case, if their employee or they had submitted the witness statement, Your Honor, the moment I moved an application saying I need the witness, we need this, they immediately, that was with regard to the amendments. The moment we made a request for these witnesses, they came forward and they agreed with us. They did not say no. But the legal effect, as I have argued in my reply, is if they would have submitted the witness statement, Your Honor, by law, the implication of law is this. If you submit the witness statement, which means you have a different view, which means it is not a straightforward case. I mean, the law of immediate judgment is, it should be a simple and a straightforward case. The moment you submit your witness statement, the case goes to trial. The moment they would have submitted, I would have said before this honorable court, now they have submitted the witness statement. Court can see their stand is different from our stand. There are tribal issues that need to be looked into. Now, Your Honor, this is another important point that I wanted this honorable court to bear in mind. Your Honor, now coming to, against this backdrop, against the important issue that was raised in these cases, my learned counsel said that I had stated, and he pointed out to you in the submission, that DIFC courts can only apply. Now, DIFC courts can only apply the DIFC regulatory law. In this case, my point is, I'm not saying as a general rule. I am saying that in the instant case, DIFC courts can only apply the DIFC regulatory law. Now, Your Honor, I will explain why. Your Honor, before I take you into IGPL and Corinth, I have two important observations in this regard. DIFC, what is my claim? My claim is about, my initial claim was about, original claim was about DIFC, violations of DIFC regulatory law. I have not come before this court and said this particular agreement, this clause, this particular agreement, because what has happened is the violation of the applicable regulatory law of the DIFC. Before I come to the issue of jurisdiction and why DIFC law will apply, the issue is, I use the word, in this case, only DIFC regulatory law will apply and other DIFC laws will apply. Because it's not, I am aware that if parties choose their own law, and they refer to Article 6 in that regard, and I'm going to come to Article 6. If parties choose their own law, governing law, then that law will apply. But there's also a proviso there. And I will read that proviso just in 1 minute before you. But suffice it to say that if this court can only, the regulations, the regulatory law is for my protection as an investor. The regulatory law is the law that defines my code of conduct. The regulatory law is the law that lays down the standards that every regulated entity in this country would follow. So therefore, if this regulatory law is breached and there is an authorized person who is regulated by this law, it does not matter whether the conduct was within DIFC or conduct was outside DIFC. What matters is there was a breach of the regulatory regulations. For me as an investor, Your Honor, what matters is that the protection that was afforded to me by law was denied, and hence I have a rightful claim. Now, mandatory provisions, as was held in IGPL case, the mandatory provisions, in IGPL case, they use the term substantive regulatory law. At para 118, 117, they use the word substantive regulatory law. What do you mean by substantive regulatory law? As distinguished from procedural law. This is the law that determines the conduct, the specific conduct. It defines the terms through which business can be carried out. Now, if this particular law is violated by any entity, automatically, even if I would not have moved this case, the regulator can take a suo motu action against that particular entity. Now, Your Honor, I have a right to enforce that, and I'll explain why. I have the Corinth case. Before I take you specifically, because this is a case which we all have read so many times, Your Honor, that if I open the case again and read out the terms again to you, it may not make much sense. But Your Honor, what happened really in this Corinth case? The principle that was laid out, the essence of the case, or the ratio of the Corinth case, is as follows. You have a bank which is outside of, which is a UK bank. It is operating in UAE, not in Kazakhstan, Almaty, in UAE, through two branches. One branch is in DIFC and one branch is in Dubai. But the branch in DIFC, Your Honor, and the branch in Dubai, Your Honor, is unincorporated. So, which entity is incorporated in DIFC? The entity which is the parent company. The parent company, which is Barclays Bank UK, is incorporated in the DIFC. Now, an act happens with regard to some employee in a Jebel Ali branch. And they say that this has no connection whatsoever with the DIFC branch. DIFC courts, of course, it's related to the issue of jurisdiction, but DIFC courts held in the instant case that as long as 5A, 1A of the judicial authority law, you fall within it, means you are a licensed center establishment pursuant to Article 2, which means an entity regulated by the laws of this country, laws of the DIFC. So you will automatically, we will assume jurisdiction over you. Now, that was a different case, Your Honor. But the principle that was laid down is that this bank, which is a UK bank, cannot escape liability, because when you dealt with that UK bank, whether you dealt with it in Dubai or you dealt with it in some other part, you know for a fact that it is regulated by the DFSA regulations and the regulatory law will apply. Now, Your Honor, I want to give a very simple example in my case. My case is about a product. My case is about selling of a product, mis-selling a product. If we look into this product and if we look into the submission of the defendant, they say that this product was from the Standard Chartered Bank, UK. And this was meant for investors in UK. Subsequently, this bank brings this product, Your Honor, into UAE. Now, A point to note is that the DIFC branch, they don't sell this product through the DIFC branch. They sell this product through the Dubai branch. Now what is the difference? Now if we go by their interpretation that there is no link with DIFC, and that should be taken as the basis, contrary to what Corinth has held, then this product, if it is so harmful, if it is so bad, that it is not fit to be sold in DIFC, are they arguing that it is fit to be sold outside of DIFC? Whether I'm an investor in the UAE, I live in the UAE, if this product is not fit to be sold in the DIFC because of the DIFC regulatory law, I'm afraid it's not fit to be sold outside of DIFC. Now, Your Honor, with this backdrop in mind, I want to take Your Honor to what they argued, which is Article 6 of Law Number 12 of 2004. This is very important, Your Honor. They relied on Article 6. And this is Volume 1, Authority Bundle, tab 3, page 18.
Article 6 of 2004, which law?
This is Law Number 12 of 2004, Judicial Authority Law, Your Honor.
Okay.
With your permission, Your Honor, I just want to read 2 lines from Article 6.
Yeah, bundle 1.
This is, Your Honor, if you see Authorities Bundle, Volume 1.
Yes.
And if Your Honor can turn to page 18.
Okay.
Page 18. It says Article 6.
So, bundle 18?
Yeah, page at the bottom, it will be written page 18. And this is bundle, volume 1, Authorities Bundle, tab 3. Tab 3, sir.
3.
Running page 18.
Yes, yes.
Your Honor, this was the main, one of the main arguments. Their argument was that they said that I have stated that DIFC court should only apply the DIFC law, and I am wrong. Now I want to distinguish this. Article 6 says, the courts shall apply the laws and regulations of the center. Now, Your Honor, it says except where the parties of the litigation explicitly, means they should agree that another law shall govern the dispute. Now, Your Honor, proviso, provided that such law does not conflict with the public order and public morals. Now, Your Honor, if I rely on the interpretation of Article 6, if I rely on the proviso of Article 6, if I rely on the fact that parties are free to make their choices in their respective contracts, but parties must not act in such a manner that it violates the public order and public morals. Now, Your Honor, let's apply this particular provision to the facts of the instant case. If regulatory law, suppose this Honorable Court holds that DIFC regulatory law shall not apply. Now, if protection of regulatory law is denied to me, what does it mean? It means that I was unable to bring to the attention of the court that they treated me, I was the retail customer, they treated me like a client. They did not follow any of the regulatory requirements that were there in the law which were for my protection. Therefore, even if they refer to some agreement and that agreement says it should be outside of DIFC, I am afraid this court cannot give up its jurisdiction because it will offend public morals and public order. I just gave an example 2 minutes ago. I brought to the attention of the Honorable Court that public, if I am outside of DIFC and this product cannot be sold in DIFC because of regulatory constraints, because it's not permissible, but this product, the same regulated entity, which is Standard Chartered Bank UK, which is regulated by DIFC is selling this product in the same country. It's through another branch, thinking that the regulatory law will not apply. Now, Your Honor, this will offend. If you say regulatory law will not apply, this will offend public order and public morals according to Article 6. Now, Your Honor, they also refer, if you see the skeleton, because I must first take the arguments against me. I must first respond to the arguments which they have used against me. They used Article 6, Your Honor. Now, if you read Article 9, now Article 9 of DIFC Law number 10 of 2005, this is a law relating to application of DIFC law. This is volume 1, authorities bundle, which you have in front of you. Your Honor, it is tab 8, page 39. Yes.
Yes.
Your Honor, Article 9 says, an express choice of a governing law of an express choice of a governing law in a contract shall be effective against all persons affected thereby. So they are saying, and I will take you through those 4 governing provisions of those 4 agreements. But they are saying that based on Article 9, an express choice has been made, therefore you are bound to follow the governing law. Your Honor, Article 9 is subject to Article 6. In Article 6, the proviso says, I will accept the governing law provided that it does not affect the public order and public morals. Now, Your Honor, there are 2 types of rights that we are talking about. When I talk of the regulatory law, Your Honor, there are 2 types of rights. One are those rights that, Your Honor, flow from the contract. We call them contractual rights. One are those rights, Your Honor, that flow from the law, from the rules and regulations, from the regulatory law. And they are non-contractual rights. They are rights which are legal rights. Now, regulatory law falls into that category. There are certain rights which I acquire from a contract, and there are certain rights which I get from the law of the land, which are for my protection. So these legal rights, Your Honor, which is the regulatory law, are guaranteed to me by the regulatory law. Now, for the protection of the regulatory law, in order to determine if there are any breaches of the regulatory law, the courts of this country, the DIFC courts, which are the courts that oversee the implementation of the DIFC regulatory laws, cannot give up their jurisdiction. They cannot relinquish their jurisdiction, even if I had chosen a governing law. I'm going to demonstrate to you today, based on the fact that that's not the case in our instant case. That I will demonstrate to you. But right now, I want to lay out the general law that an authorized firm is bound by this regulatory law. An authorized firm cannot say, I'm operating through another branch outside of DIFC, therefore regulatory law does not apply. Now, if that proposition, Your Honor, were to be accepted by this honorable court, then the entire protection would not, I mean, I'm sorry, but it seems like it would vanish in thin air. So then if I have to seek the protection, I have to be within DIFC. The moment I step out of DIFC, so you're permitting an entity to act lawfully within DIFC and unlawfully outside of DIFC, if that would be a correct phrase to use. Now, Your Honor, parties cannot contract out. I just raised this provision. Now, if this is the regulatory law, we and the defendant cannot enter into an agreement amongst ourselves that regulatory law shall not apply. Even if we write in an agreement that DIFC regulatory law shall not apply, DIFC regulatory law shall apply insofar as the breaches are concerned. Your Honor, I made an amendment to my statement of case because I had not pointed out other violations of DIFC laws. Even if suppose I had not made those amendments, suppose I had not made those amendments at all in my statement of case, this honorable court would have still looked into other violations of DIFC laws, because that's what the job of the courts is. Because in their defense they said, we do not believe that the regulatory law applies. I made amendments to that to show that not only DIFC law, but other laws are also violated. I want to argue here that I want to bring to your attention now a very important observation from the court of first instance in the Bank Sarasin case. Your Honor, Bank Sarasin case is absolutely identical to our case, except one point. In Bank Sarasin case, they also sold some notes, they leveraged them, they called, there was a margin call, they deducted the money, they filed a claim in the DFC courts. But there the bank Sarasin was also within DFC. The issue there was not that there's an entity outside of DFC. But if we use the current authority, Your Honor, then my case, then irrespective of the fact, the summary of current cases that if there is a regulated entity in DIFC, which is Standard Chartered Bank in the instant case, then it will continue to be a regulated entity, even if it operates outside. Now, Your Honor, Article 10 of the DIFC law says, and this is quoted in Bank Sarasin as well, that all licensed center establishments shall be governed by the terms of the license, shall carry out their activities in accordance with the license. What does that mean, Your Honor? It means that Standard Chartered Bank, whether it operates inside DIFC or whether Standard Chartered Bank operates outside of DIFC, Standard Chartered Bank must conduct its operation in accordance with Article 10. Standard Chartered Bank must conduct its operation to ensure that it is complying with all the laws. It must take into account all the formalities and all the protections that are required in the DIFC will apply also outside of DIFC. Now, Your Honor, I draw your attention to Volume 3, Authorities Bundle. This is a small book like this, Your Honor. It will say Authorities Bundle 3.
Yes.
Your Honor, this is the judgment of the Court of First Instance in the Sarasin case. And I am drawing the attention of this Honorable Court to para 325, which is at page 76.
Paragraph.
Your Honor, I want to take you through, if you look into where this para ends, just before 326. Let's go up 10, 15, 12 lines up. It says, the parties are agreeing. Your Honor has found that point?
Yes, yes.
The parties are agreeing that the statements in the report shall be the case for the purposes of the contract of sale and parties cannot go, okay, sorry, just below it. If it is indeed submitted that the claimants or any of them are stopped from asserting that they are not clients by reason of AGBCs which they signed, I reject that submission. In my view, regulatory law and rules do not permit parties to contract out of the protective provisions in the COB rules. A party who is on proper analysis of the facts a retail customer because he or she does not in fact satisfy the conditions in subparagraph 1 and 2 cannot agree to be treated as a client. Your Honor, in this case, in Bank Sarasin case, we had these AGBC forms which we had to fill in. In that AGBC, we clicked client. So you cannot, so I'm a professional client, so I am. So the court said, one of the tests in the Bank Sarasin case was that even if you say you're a client, the bank must satisfy itself by circulating 10-15 questions to you to know if you actually have the competence to deal in a wholesale financial center and to deal with these sophisticated structured products. The point for the reference that why I quoted this, Your Honor, before you at this stage is to bring only one point to the attention to the reference of this court, which is we cannot, Your Honor, contract out of the mandatory provisions of a regulatory law. Now, if the defendant were to argue, and they have rightly argued, that we are a licensed center establishment, they looked into IGPL and they said, IGPL, we were the beneficiaries in that case, we won that IGPL case, and we agree that we are licensed center establishments. If they are licensed center establishments, then pursuant to Article 10, the laws of the center, they have to carry out their activity in accordance with the terms of the license. In or from DIFC, it has to be carried out according to the terms of this license. The branch is not incorporated, Your Honor. It is the parent company that is incorporated. The parent company cannot go out and act through the branch in flagrant violation of these particular rules. Now, Your Honor, again I draw the attention of this Honorable Court to paragraph volume, now I want to take you through the Court of Appeal. Volume 1, Authorities Bundle, tab 18.
Authority Bundle.
Page 208.
Tab.
Your Honor, tab 18.
18.
Yes, Your Honor.
Authority Bundle 2.
Yes, Your Honor. I apologize. Your Honor, paragraph, this is page 208. I am referring to paragraph 228.
Paragraph.
Paragraph 228, which is at page 208. Volume 1, Authorities Bundle, tab 18,
Tab 18.
18.
Page number
208, Your Honor.
208, yes.
Your Honor, now the Bank Sarasate, there was a judgment of the Court of First Instance. Now this is not a judgment, but this is an observation. Now even when the Court of Appeal was examining the observations of the learned judge in the Court of First Instance judge, they said at paragraph 228, with your permission, if I may read, the last argument by Sarasate Alpen in this sequence is that the respondents were stopped from contending that they were not clients within the meaning of the rules. This raises similar considerations. As the judge held at paragraph 325, which I just read out to you, it is not permissible, now this is the Court of Appeal of the DFC, it is not permissible to contract out of the rules in the sense that a retail customer who does not meet the conditions required for the acceptance as a client cannot agree to be treated as one. Your Honor, it's a very interesting situation. Let's say that I am the person who says before you, yes, I am a client. This Honorable Court tells me, it does not matter if you say you are a client. We look at your qualifications and we believe that you are not a client. So, because we have to look into the mandatory provisions of the applicable law, we don't have to look into what the parties have agreed. We don't have to look into what you have stated. The reason I'm drawing this analogy, Your Honor, is to bring home the point that if regulatory law, which is the law that governs these entities, governs the relationship between these entities, is for the laying out the code of conduct of how these authorized firms should carry out their business, then that business must be carried out in that manner. And if that business is not carried out, now Your Honor, let's say they say that Dubai courts have, this should be governed by, the case should be dealt with UAE law. We have a small problem. Small problem is, Your Honor, I recall the decision in IGPL, Article 3, it says CPC, the financial free zones are exempt from the operation of CPC. Now, Your Honor, CPC unfortunately cannot apply. This court cannot look into the provisions of the civil code. Therefore, this court has to look into other laws that are available. So the most favorable law that this court will look into, Your Honor, is the law of the DIFC. This court will say that this law, even if this is not the choice of the parties, assuming for the sake of an argument, but not conceding, this to me appears to be the most relevant law to apply in the instant case because it pertains to the conduct of a regulated entity, it pertains to a product that was sold within UAE, the regulatory restrictions that were meant to be followed by this authority were not followed, hence I have jurisdiction. So the question of the non-application of DFC law does not apply in the instant case. Now, Your Honor, let's go to the IGPL case. The time has come to enter the IGPL case. This is Authority Bundle 1, tab 15.
Yes.
Your Honor has that?
Yep.
Your Honor, there are two main issues in this case. My learned counsel said that in this instant case, the DIFC courts applied both the UAE law and they also applied the English law. Your Honor, the main issue in this case was because the IGPL contended that Sharjah is the most appropriate forum and the court was looking into various issues, including the issue of forum non-convenience, and held the most important observation in this case was that current case has been rightly decided. We uphold current. We hold that CPC does not apply. We hold that SCB is a licensed central establishment. We hold that there is no transaction-based requirement that is required. So if you have dealt with SCB, if IGPL has dealt with SCB, IGPL has assumed the risk that it can be, SCB can bring a lawsuit within the DIFC courts, irrespective whether it has link or irrespective of the fact whether there is no link at all. And there was also the issue of English law, and the learned judge held that English law can more appropriately be decided by these DIFC courts. Now coming to the observation, now I want to tell you, the entire submission, not the entire submission, I stand corrected, a main part of the submission of my learned counsel was the laws of DIFC cannot apply outside, the laws of UAE cannot apply, and he was referring to a situation. And he said that it is not possible for us to look into, for the DIFC law, DIFC courts look into the DIFC law. Now, Your Honor, I want to read out one paragraph that he didn't read. He read to you paragraph 116, 117, but there are two paragraphs, in fact, which he did not read. From paragraph 118.
From which document?
This is the IGPL case, Your Honor. This is Authority Bundle 1, tab 15, page 102.
102. Okay.
Your Honor, with your permission, it is slightly important if you permit me, because I want to read this. Actually, these two paragraphs set the tone for what the case is all about. Now this is paragraph 118. Okay. IGPL also argues that its narrow interpretation is justified because there must be unity. Now, Your Honor, this is very important because I myself had to read it several times to understand this proposition. There must be unity between the territorial scope of the DIFC regulations and the DIFC court's jurisdictional reach. IGPL put this argument in the following terms. Now what I'm reading, Your Honor, is exactly what they argued. 92. In short, once a branch has been established, licensing, regulation, and the carrying on of the activity are correlatives. Business can only be carried on pursuant to the relevant license, which engages the relevant regulatory and jurisdictional regime. SCB possessed licenses to carry on business both in Dubai and in DIFC. The critical question must then become, pursuant to which license was the business in question carried out? The business relevant to the present dispute was carried out in Sharjah and or in Dubai, but not in DIFC. Hence, the applicable licensing, regulatory, and jurisdictional regime cannot be the DIFC. This is the same argument that was advanced before this court just now. Thus, in order to carry on business activities in the DIFC law area, SCB needed separate and distinct licenses from those that it needed to carry on business activities in the Dubai law area. The commercial license issued by the Dubai government did not cover SCB to carry on business activity in or through the DIFC, and SCB needed additionally to obtain a separate annual DIFC commercial license. Thus, the separate law areas of Dubai on one hand and DIFC on the other are strictly maintained and observed. Clearly, the regulatory regime and jurisdictional reach of the DIFC law area can apply only to business activities carried out in the DIFC. Your Honor, I do not see any difference between what I read out to you and what was pleaded before this honorable court. But if you read the very next paragraph, which is the most critical paragraph of this entire case, Your Honor, it lays out a very interesting scenario. With your permission, Your Honor, paragraph 119, which follows paragraph 118, reads as follows. Where IGPL's argument has taken a leap of logic is in conflating meaning combining the DIFC's substantive regulatory laws and the DIFC's procedural, in our view, and contrary to IGPL's suggestion, there is no necessary connection between the two. Your Honor, it's talking about, IGPL was trying to say that the DIFC procedural law and the DIFC regulatory law, there must be unity between the two. The court expressed great apprehension and said that in our view and contrary to this suggestion, there is no necessary connection between the two. And then it explains, Your Honor, this is the critical observation. A jurisdiction may enact extraterritorial statutes prohibiting certain conduct taking place abroad, even though its court's jurisdiction over an entity falling afoul of those prohibitions turns narrowly on proper and effective service of this entity. Equally, a jurisdiction may enact regulations which cover only activities taking place within its territory, but prescribing jurisdictional rules which permit its courts to hear disputes concerning the conduct taking place abroad. No absurdity, Your Honor, no absurdity arises in either scenario. It seems elementary to us that substantive rules and procedural rules operate on different planes, so there is no merit in IGPL's substantive suggestion that there must be unity between them as related to the scope. Now, Your Honor, I want to interpret this very interesting observation of this Honorable Court in this IGPL case. Your Honor, a distinction is being made between the procedural law and a distinction is being made between the application of the substantive regulatory law. In the instant case, the court goes on to hold that. It says equally a jurisdiction may enact regulations. DIFC has enacted regulations, the regulatory law, which cover only activities taking place within its territory. But this is Your Honor, this is the fundamental point. So DIFC has framed laws which cover activities taking place within its territory, but it prescribes jurisdictional rules which permits its courts to hear disputes concerning conduct taking place abroad. Now, Your Honor, let's say that Dubai is abroad for the sake of an argument, and DIFC is where the rules have been framed. If what I have called into question before this Honorable Court today, Your Honor, is the conduct of some employees of the bank who were acting for and on behalf of the bank with the knowledge and consent of the bank, who induced me to invest in a product which was extremely high risk, and then subsequently when the product was triggered, a halt was triggered, which was frozen, I was then induced to take out my investment and put it in a fixed deposit because there was an IRS agreement. They wanted to get 5.24% of this interest at the end of the year, and that is why, Your Honor, they did not allow me to close my loan at that time, the facility, when this product was frozen. They said, you have to continue, you lost 400 something, you will lose more. If you want to get more, you have to wait till the end of the term. Now, Your Honor, I am not expecting 3 million from this. I was not expecting 3 million as I have written in my submission. I was only saying 1 million is my capital protected investment. Will I get my 1 million back? This was my only concern. And I was not saving my 3 million. I knew that the money will go towards leveraging the loan and other things. I was only trying to save my 1 million. So my issue was not to make a profit. My issue was how to save myself. Now, Your Honor, I am bringing to your attention, if this is a straight and a simple case, Your Honor, how can an immediate judgment be given where there are issues, Your Honor, which need to be adjudicated upon, where this Honorable Court, after all, this Honorable Court has to establish facts. If, Your Honor, the facts have not been established, if, Your Honor, there is no witness statement of the opposite side, if, Your Honor, this Honorable Court is not able to see what Mr. Adam Padansi said. Now, Your Honor, we cannot conduct a mini trial in this case. I'm happy to read out to you, with this Honorable Court's permission, the entire witness statement of my client and demonstrate to you what happened in this case. I am willing to read out each and every single email and document which my client has written to the opposite party, Your Honor, to demonstrate to this court that what has happened. Your Honor, in fact, now that I'm referring to it, I'm just tempted to read 1 or 2 letters just to demonstrate to this Honorable Court that look at how this issue has been carried out. Your Honor, I draw the attention to Application Bundle, Volume 2.
Yes.
Page 137.
Tab.
Your Honor, we are at tab 17. These are the annexures to the witness statement.
Then
I want to read out to you.
page number.
Page number, Your Honor, 137.
Yes. The bottom one, right?
Yes, Your Honor. Your Honor, this is dated August 18, 2011. And I am writing to Mr. Jeremy Parish, who is the CEO of the Standard Chartered Bank. Your Honor, I need your permission to read this so that I can bring to your attention the point that I want to convey.
Yeah, go ahead.
Thank you, Your Honor. Dear Mr. So-and-so, first I am sorry to disturb you directly at such timing, but I judge the situation very complicated to solve and need the legal touch. So I apologize for the English, but this is how it is written. Actina FZCO of Jebel Ali is a client of SCB since 2002. I wish to bring you my complaint. We are a French-Japanese company located in France, Tokyo, with a trading office in Jebel Ali since 2002, producing, selling French and Japanese tea brands. It's a tea company. Our problem with Standard Chartered started in 2009 after an investment GYM that left us with more big loss of more than $500,000. This was the amount, Your Honor, that was deducted when the money was put into the fixed deposit. The investment is capital protected. 2013 and until 2013, and we are obliged to renew a fixed deposit until the end of this period to finish this investment. So he's writing to them, we are obliged to renew this. My points are, we made this investment in 2008 July when market started going down and this investment was capital guaranteed. Number two, we did not receive, now Your Honor, this is the point I was trying to convey. We did not receive any official documents from the bank explaining the mechanism of consequences with internal regulatory and compliance okay on it. The bankers insist of face-to-face meeting. The bankers insist on face-to-face meeting where they bring the financial expert who will explain to us verbally things we don't understand. Neither the staff of the bank do. So verbal communication is the norm. And when you will come to Dubai is the answer for our requests. Since 2009, our company's sales expanded 700%, zero debt, so and so. Today, 2011, same people are treating us the same way as in 2009 as the bad clients, and this makes me more angry and start treating them the same way. We must call them to remind fixed deposit need to be renewed in 18th August, knowing that if it's not, we will lose additional money. We are in no option. My request, next page, my request to you is very simple. I wish you will give us, now Your Honor, this is a very reasonable request. I wish you will give us a written document explaining this investment failure reasons. Based on all written documents, agreements, why banks, now Your Honor, this is the case, why banks needed our signature after the investment failed and stopped. If we did not sign on them, our operations were frozen, making us feel the operation was not legal and finding an issue to this problem. Your Honor, another issue that we have written in the witness statement is, of the client has testified is, that at that time when this product failed, there was only an agreement for 4 million facility in place. And that 4 million facility agreement, as I will demonstrate to you just now, expired on 4th of May. In May, just before this was to be renewed, it expired. And in fact, I have it written here. It expired on, facility agreement was dated 19th of May 2008. This was the only agreement we signed for 4 million facility. This was valid until 7th April 2008. 7th April 2008. In the month, they say there was an agreement for 2009, June 2009, for an amount of $2 million. They say we signed this agreement in 2009 with them to regularize the accounts. Now, Your Honor, I have written everything in my submission. They say to regularize the accounts. Why would no facility, Your Honor, of 4 million was ever given? I was not even aware that they have drawn down 2 million into my account. I have written this also in my submission. And if this agreement was valid until 7th April 2008, how can, under a loan agreement, a facility agreement, which is valid, a facility is given to me, and then that agreement becomes has a short duration of 7th April 2008, and you have to sign a new agreement after this thing has happened to regularize your accounts? They have not explained to this honorable court what the word regularization of the account means. Again, Your Honor, this is a tribal issue. This is an issue that cannot be adjudicated right now by this court. This is an issue that can be adjudicated during the trial. Now, Your Honor, going back to the same issue that I was reading out to you a letter. There is one more point, Your Honor, I did not bring to your attention. Your Honor, this product that I'm talking about, which they sold to my client, and they can confirm, was not approved at that time by the central bank. It was only approved later in March 2010. They have written it in their submission, Your Honor. Now, a question arises, Your Honor. And the question that comes to my mind is, if you have a product which has not been approved by the central bank, and their answer is, they're actually responding to that. They said that the reason why this is not important is because there was no requirement at that time to seek the approval of the central bank. Now, Your Honor, if a product not approved by UAE Central Bank is sold in this market, is sold in this country, is sold in UAE, whether it is inside UAE, whether it is outside UAE, it is sold by a regulated entity. Your Honor, this court has to look slightly more carefully into that product, because that product has not met the requirements of the UAE Central Bank. Now, this is very clearly articulated by them, Your Honor, in the submission. And I have, if you see one of my replies, I have argued that there are 6 questions that this court must take note of, and that is in my reply. I will take you to those 6 questions, Your Honor. When I talk about this product, it's
Application bundle 1.
reply 20. Where's my reply? One of the 2 replies.
Are we looking to your reply?
Your Honor, 1 minute. I apologize. Yes, Your Honor. Your Honor, I am referring to, as Your Honor rightly referred to, volume 1. Your Honor, this is tab 7.
7 or 15?
7.
Yeah.
And page I'm referring to is 145.
Okay.
This is my submission, Your Honor.
Tab 7, page
145.
145. Yes.
Your Honor, paragraph 7.5 on the top of the page. The letter dated 4th October 2010 of Mr. Jeremy Travis, the head of compliance of SCB, confirms that the relevant FX SCB product, they refer to it as YDA product, it's the same thing, was approved for distribution to individual customers on 10th March 2010. Defendant does not deny this confirmation. Instead, at paragraph 9.3 of its defense, it confirms that the FX SCP product sold to the claimant was not required to be registered in May 2008, meaning it was not approved by the UAE Central Bank. Now, in this regard, I bring to your attention paragraph 7.6. Your Honor, there are 6 important questions that arise for determination by this court. First is, if there was no requirement for registration of the product at the relevant time, as is being alleged by the defendant, then does it mean that the defendant could have sold such a high-risk product, not from its DIC branch, but from its Dubai branch, without following the appropriate risk disclosure requirements that it was required to follow as per the norms of DIC? This is my first question. My second question is, once this product was approved for sale to individual customers in 2010, in March 2010, what were the registration requirements? Were they more onerous than the pre-registration which they followed in determining to whom the product was sold? That is another way of finding out what were the new restrictions that were imposed. And number three, as the Standard Chartered Bank Dubai branch was selling the product of the Standard Chartered Bank London, now Standard Chartered Bank London, which is regulated in DIFC, was it not bound to adopt the same standards in Dubai that would apply to sale of such products in UK under the FSA regulations? Fourth, notwithstanding the registration of the FXSCB product, is it not true that the defendant continued to be and is still regulated by the laws of the DFSA? Number five, is it not true that DIFC courts have a compelling interest in exercising compulsory jurisdiction over the Standard Chartered Bank UK being regulated by it, as there are, so to speak, allegations that prove that the bank acted in a manner contrary to the established law of the DIFC? Lastly, if there was no facility agreement in place for 2 million dirham alleged to have been provided to the claimant, then what is the relevance of other ISDA master agreement and interest rate swap agreement? Your Honor, and just below it, I just when you get a chance to read this, Your Honor, please look into this next paragraph as well. There was no written communication. I don't want to read it because I already read out a letter to you in this regard. Your Honor, it is my simple.
Can I stop you
Yes,
just to
sir.
clarify the fact here? Does the claimant ask for any qualification? Does the claimant ask for any approval? Does the claimant, when get engaged in this in 2008, ask the bank to show any approval of this product?
Your Honor, there is a full witness statement where there's a communication between the two, where the client tells the bank that I am looking, as I have invested with you before, I'm looking for a product that is 100% capital guaranteed, fully protected. Now, anything that the bank sells to the client. Your Honor, if my client was a sophisticated client, represented by someone very
My
good.
question is very simple. When the client, your client, and the claimant enter this agreement, in this engagement in 2008, right? Or 2000?
Yes.
Before that. And my understanding, the client has different engagement with the bank for different transactions.
That's correct.
So the client might ask for kind of approval of this project before they get in, or before they engage, or before they put their money in this transaction. Does the client ask the bank to show any kind of approval for this type of product, or that wasn't relevant? Or
Your Honor, it's a very good question. For 7 years before, we were banking with them. And the client explains this in its witness statement, that we had absolute trust in the bank. We told the bank to show us a product. Now, my client believed that whatever such a big bank would sell to us, cannot, after all, such a big bank, Your Honor, cannot sell a product which is not approved. In fact, this question may not have even crossed, it may not cross anybody's mind, least my client, because my client was already banking with them. So it was not expected that this particular bank would ever, in the wildest of the dreams, sell a product which would, in fact, my client tells I can read out that relevant passage, says, I need a product which is highly safe, highly secure. Can you, I will take you through that relevant paragraph, the witness statement of Mr. Bejit Ideas, which is at paragraph, which is at bundle volume 2, application bundle.
Where I have to go?
Volume 2, application bundle, tab 16.
So when the defendant say there is no requirement to show any kind of approval, this is what we need to clarify. Require from whom?
Because only a product, normally banks will only sell a product which is approved by the UAE Central Bank or by the DFS regulatory authority. So only those products which are approved by the relevant regulatory authority can be sold in the market. Now, at that time, Your Honor, in 2008, according to them, that there was no requirement for registration of a product or approval, seeking approval of a product. Hence, we did not obtain it and we are not in breach of any law because it was not a requirement of that time. We came to know about it subsequently because we wrote a letter to the central bank asking for these. We wrote a letter to them. Subsequently, we asked them these questions. How can you sell such a high-risk product? It brought a doubt in their mind. And they said to us, yes, this product, Mr. Jeremy Davis writes that it was approved for after March 2010. That's when we came to know that it was not approved at that time when we purchased it.
But at that time, 2008, that product was approved by London, let's say, by regulatory authority in London?
It was meant for
because
use in London only.
Like a London product.
It was London product, Your Honor, meant for. It was bound by the FSA regulations in London. We don't know the manner in which the product was sold to us. You see, under the FSA regulations in London, Your Honor, they are almost identical, or almost our regulations are almost identical to them, Your Honor. So they would have followed. Suppose they had to follow the FSA regulations, Your Honor. They would have still asked the client, are you a professional client? Are you a retail customer? Do you understand the nature of this investment? Do you not? So they would have done that, Your Honor. Now coming to the point, when you ask me this question, I would request you, Your Honor, if you want, I can read it, or I can indicate only the paragraphs that you
just indicate.
Your Honor, kindly, when you have a moment, kindly look into the witness statement which I have given you the details. From paragraph 6 onwards.
Yes.
Until, if you could go through, at least until paragraph 16. So that will give you the idea of what was the relationship between the parties and what were the circumstances when my client entered into a business relationship with the Standard Chartered Bank.
My understanding, whether the project is registered or approved or not approved, this is for the regulatory authority to have a word with, take action against the regulator, but not for the client.
Not for the client.
So for the client, this depends on the client first, whether he will get engaged in a project to find out whether this project is already secure or approved or not approved. So this would be, again, the client decision.
Your Honor, absolutely correct. And to be honest with you, the client had no reason to disbelieve the bank or to imagine that a particular product sold to me would not be approved. I mean, this is a presumption. I mean, there's sometimes, Your Honor, I've dealt with cases where people go and in a particular real estate office, they went and signed the contracts. And then they believe that the person who is signing on behalf of the concerned real estate authority, real estate company, had the authority to sign. Then that real estate company comes forward and says, this person did not have the authority to sign on their behalf, hence his contract is not valid. So, Your Honor, there is at least an ostensible authority or some sort of an understanding that what is being given to us by such a regulated entity will meet the requirements of the law. Now, Your Honor, in this particular instant case, the whole issue, I don't want to repeat any of the arguments. I just want to come only to the points which my learned counsel has raised and tackle them one by one because all my submissions are in extreme detail before this honorable court. Your Honor, it is not possible if I look at it not as a counsel for this case, but if I were to look at it, imagine, Your Honor, today a statement of costs has been submitted to this honorable court. Now, if you look into the value of, I don't want to mention here, but if you look into the amount that has been claimed as the fee, in a straight and simple case, if it was a straight and simple case, why was there a need for such extensive voluminous documentation? If it was a straight and simple case, then why was on the same day you filed your statement of defense, why did you not file your application for an immediate judgment? Because if the grounds for filing an immediate judgment existed earlier, now they existed earlier as well. Now there are lots of questions, Your Honor, which I don't want to get into, but I just want to raise the points that this is an arguable case. I want to bring to the attention of this court that Your Honor must read one important thing. There are some material discrepancies, and I will only indicate where Your Honor must look into. Read. This is volume 1, tab 7, page 126.
26.
Page 126. Your Honor, this is very important. These material discrepancies that I have pointed out are very important. And this is in my 25th December reply, Your Honor. There are only 2 points which I want to bring in this thing to your attention, so they are mentioned there. Should we open it, Your Honor, and read
That's
this?
fine, go ahead. I will.
This is, Your Honor, no. Here. Tab 7, volume 1.
126.
Volume 1, tab 7, page 126.
Yes.
Only 2 points, Your Honor. In this reply, claimant notes that the defendant admits that the facility agreement dated 9th June 2009. Now, Your Honor, this facility agreement is only dated 9th June 2009. It was not signed on 9th June 2009. Was for 2 million. Was not executed in May 2008. The defendant agrees with us, Your Honor, because in May 2008 we had a 4 million agreement. As stated in paragraph 12 of the second witness statement of Mr. Bijit Ideas, the relevant facility agreement was not executed on 9th June 2009. It was undated. It may have been executed sometime in July, August, September of 2009. Will this court not be interested to find out that if facility was provided to me, to my client, when was this facility agreement provided? Will this not be an issue to be established before this honorable court, that when you provided the requisite facility, as you claim to have provided of 2 million, why did you sign a 4 million agreement? Why did this 4 million agreement expire in May? And then why did you sign after a few months a new agreement for 2 million? What do you mean when you say regularization of the accounts? And the very next point, the defendant confirms that the relevant facility agreement dated 9th June was executed in 2009 with a view to regularize the accounts. Now, Your Honor, some facts were read out to you today. In those facts, it was not brought to your attention that we don't have the exact date on which this facility agreement was signed. Now, let's assume for the sake of an argument that there was no facility in place on that relevant date, because what was happening is as follows. I have an account with the bank. Bank has all the record. Bank tells me I gave you this. Bank on its own says now you have invested in this product. And then subsequently, Your Honor, this bank tells me now you have lost this much, now we are deducting this much. Now you have to take this money out. So nothing physically happens, everything happens within the frame of reference of the bank. Now, Your Honor, this is an issue which needs to be established by this honorable court. My point is, coming back to Article RDC 24, I need to establish before this court, I'm making a mistake. I'm going actually to establish before this court that all I need to show is that I have some basis. I'm trying to show you my strong basis. What I need, my burden of proof before this honorable court today is discharged when I tell before this honorable court that I have some grounds on the basis of which I can defend my case. And my case has a reasonable prospect of success. If not 100%, it has reasonable prospect of success. Now, Your Honor, because time is of the essence, I don't want to go into these issues again. on the subject of all these. I have covered my point. My submissions are before the Honorable Court. I only want to go into 4 agreements that are in question in this case. The first agreement is, I don't want to open this agreement and go through it because that will take time. I will just indicate, Your Honor, and this can be looked into. First is the structure deposit agreement. This was executed on 15th May 2008. Now, the clause 5 of this agreement, Your Honor, says that this structure deposit agreement shall be governed by the laws of the UAE. Second part says, parties agree to submit to the non-exclusive jurisdiction of the UAE courts. So it refers to the UAE laws, and it says non-exclusive jurisdiction of the UAE courts. The Federal Civil Code, now Your Honor, Federal Civil Code, as we have seen in IGPL case and in other cases, does not apply to the DIFC courts, because Article 3.2 of Federal Law Number 8 of 2004 very clearly exempts the financial free zones from this issue. Now there are 2 arguments before this Honorable Court on this submission. What is this word? When the reference, it says this agreement should be governed by the laws of UAE and the law courts of UAE should have exclusive jurisdiction. What does that mean? Now, insofar as laws of the UAE, Your Honor, since Standard Chartered Bank, we don't dispute the fact it is an authorized firm in the DIFC. So, law that will apply to it will be the DIFC law. So, DIFC has the most strong connection with this entity. So, when we use the term in the structured deposit agreement, that the laws of UAE will mean laws of the DIFC. It will not mean laws of Dubai. It will not mean laws of any other law, because Federal Civil Code cannot apply. So it can only mean that laws of UAE will mean the DIFC law. Second point, Your Honor, since Article 3 exempts, so only law that remains in the field, if Federal Civil Code is removed, the only law that covers the field that remains is the DIFC regulatory law, is the DIFC law. So DIFC law will apply. Second agreement that we have is a YDA, which is this product confirmation form. And if you look into this YDA, it again says laws of UAE shall apply by the same analogy as I have. Again, Your Honor, this YDA, this is a product, confirmation of this product sheet. Now, when it says laws of UAE, since this product is from Standard Chartered Bank UK, since this product has been brought by Standard Chartered Bank from UK to UAE, and it is governed by DIFC rules and regulations by the regulatory law. So when it says laws of UAE, by the same analogy, laws of UAE shall only mean the laws of the DIFC. Now let's come to the third agreement. The third agreement is Schedule 2, the ISDA agreement. It says, which we refer to as IRS, they say it shall be governed in accordance with the laws of UK. Now, Your Honor, the question is as follows. I brought to your attention the IGPL case. In IGPL case, paragraph, which is volume 1, tab 15, page 104. I'll only give the reference, Your Honor, I will not open it. If you see that, it says that the English courts, the DIFC courts are more in a better position to apply the English laws, are better equipped to apply the English laws. So reference to the courts would mean the DIFC courts. So whether you take A, B, C or D agreement, whatever agreement you take, it would mean the reference will only be to the DIFC courts. Lastly, there is a facility agreement. Now, we don't know about this facility agreement. So they have also not referred to it.
You mean agreement number 4 or number 5?
Number 4.
Yeah.
The facility agreement. Now, Your Honor, it says, if you read it inside, it says courts of UAE. Now, this facility was allegedly provided in respect of a product of a regulated entity, and that entity is regulated by DFSA regulations. So the courts of UAE, assuming that a dispute arises under this facility agreement, So the courts would necessarily mean the courts of DFC. But Your Honor, my claim is twofold. I am not bringing my claim entirely that this particular agreement, this particular provision has been violated. I am also, in addition to the pleas that I have taken, bringing my case rather mainly on the violations of the applicable regulatory law. Now, there is, this court.
You talk about 4 agreements, what about the 5?
The 5th one.
The 5th one covering what? The UAE as well, or England and
The
Wales?
facility agreement says courts of UAE, Your Honor.
We mentioned 4th so far.
Yeah, 1, 2, 3, 4. Yes, Your Honor. 4 agreements. 4 agreements.
Only 4.
Now, Your Honor, I conclude the first part, which is that insofar as the application of the DRC law is concerned, whether I rely on the regulatory law, whether I rely on other provisions of DFC law, the competent courts are only the DFC courts. Because only DIFC courts can deal with the principles of regulatory law, and DIFC courts have compulsory jurisdiction. Where there is a breach of a regulatory law, they cannot give up jurisdiction in favor of any other person. Now, Your Honor, they refer to the second issue before this Honorable Court, issue of limitation.
How long that will take?
If I say 15 to 20 minutes, I'll try my best to cover it.
I just want to make sure, you want to take a lunch break or you want to come back later
We can
on?
come back,
Because
Your Honor, if you
we have a full day hearing for this application unless...
No particular preference from us, however, you should proceed.
Because we could then have another round for you to reply to all those comments. So would you like to have a lunch break, probably until 2 o'clock, or
No difference.
as you see fit?
No difference for us. I'm happy to.
Or you want to break at 2 o'clock, or
Sure.
what do you prefer?
I would agree with whatever my learned counsel says.
Yeah. So shall we continue then with the...
Continuing is fine.
Okay, all right.
Unless Your Honor wants to take a
No,
recess.
I just want to not be distributed.
Can I have 1 minute of...
Please, yeah.
Limitation. My limitation. 23rd March. January, With your permission, Your Honor, thank you for the short recess. With your permission, Your Honor, there are now the only argument that remains in the court is the issue of limitation. I would like to bring to the attention of this honorable court when my learned counsel was arguing, he referred to 2 important cases, and one was an Australian case where there was an observation by a judge, and he referred to one more case in that regard. But before I go to that question, Your Honor, I don't want to forget these 2 points. I did not read before this Honorable Court some of the provisions of, because I thought they are so elementary, I should not, they're discussed in detail, such as J.D. Witherspoon case, which talks about immediate judgment application, fashion gossip case, which talks about immediate judgment application. And in my skeleton, I will request this Honorable Court to read my 5 pages on this, so that I can save the time of the court by not repeating what has already been stated.
Okay.
Now, Your Honor, on the issue of limitation, my stand is very simple. When a letter was read out to the court, where we had written to the central bank that I will be at a loss of $700,000, and the actual loss that took place was not $700, the direct loss. It was about $799,680. Because what is relevant, Your Honor, how did we come to that figure of 700? I think that is what the court wants to know. Your Honor, there are several communications which my client has addressed to the Standard Chartered Bank, asking them, we want to written communication from you in this regard, how much we have lost, how much we will get at the end of the year. What we were trying to, as you can see from our communication, what was of interest to us, Your Honor, was we wanted to protect our 1 million. We knew that other thing was, we don't even know what came because we never agreed to the leverage. It was just provided to us. We just wanted to protect our $1 million investment. Now, there are emails that can be read out to you which established that we were asking them all this information and they never wrote back to us. It was only in meetings that they told us. First they said you might lose 400,000. Then they said you might lose more than up to 700. If loss can be up to 700. And this is happening much in advance than this actual happening. But the actual happening, Your Honor, the actual happening of loss came when that formal notification, which they have referred to, came to us on 10th July 2013. It was on 10th July 2013 when that formal set of notification was served upon us. We came to know what our actual loss was. It was not possible. After all, there was nothing definitive that we had. All we had was hearsay. Mr. Adil Padamsi, what do you think? How much will be my loss?
Expectation.
Really, sir, I cannot tell you, but it may be more than 400. How much will be my loss? It may be up to 700. So that is what prompted us, Your Honor, to move this complaint. If you ask me what was the reason for moving this complaint, I mean, I was not a counsel then with them, but when I asked the client in an interview, why did you go to the Central Bank of UAE, he said, we thought this is the only entity that regulates. So UAE Central Bank will have a compelling interest in this issue. So I asked him, what did you do after that? He said, we followed up with, but we could not get any answers. Then we wrote to the bank. And thereafter, there are a series of legal notices that my client has served upon the Standard Chartered Bank, which are also included in the documentation available, making a demand upon them to pay the money. So, Your Honor, for the purposes of limitation, how can 2009, when this product was sold to us, or when this product was frozen, how could that be the period? The reason why that cannot be the period is because the facts of my case are as follows. My facts are, when in June 2009, this product was frozen, immediately I met Mr. Adil Padamsi of Standard Chartered Bank. Mr. Adil Padamsi of Standard Chartered Bank told me that the only way you can protect your principal, what you have left, is we will make a deduction of 400 or 500,000, and 2.5 million something is what you are going to save, and you have to put it in a fixed deposit. Every 6 months it will be renewed until the period of 5 years. When my client said, can I not close it? Can I not shift it anywhere else? They said, no, this agreement, IRS agreement, is for a period of 5 years. You will suffer huge loss if we break it. It is not advisable to break this agreement. It is advisable to continue with this arrangement. So my client said, can you give me an assurance that my interest will be protected? He said, look, insofar as your 1 million thing is concerned, it will still be guaranteed. This is the only way it will be guaranteed.
And this is verbal.
Your Honor, this is all documented. They are all emails. They have not replied to our emails.
So
We have one side of the story. We have our version. We have our version, Your Honor. We have our emails to them, and no reply in return. Of course, there are 3 or 4 replies, but not addressing these contentious issues. Your Honor, the issue which I want to bring to this attention of this Honorable Court for the purposes of limitation is, even at that time, Your Honor, because we had other accounts with them, our accounts were frozen, Your Honor, operational accounts, which had nothing to do with this investment. We were told, please sign, you have to sign a few agreements, which included the facility agreement that I was just referring to. And these accounts will be unfrozen because this is a compliance requirement with the bank. My client did the way he was told. My client complied with every single request that was given to him. So even at that time, my client had hope. The point I'm trying to convey for the purposes of limitation, Your Honor, is even at that point, my client thought, okay, I will not get 2.5 million back, at least it is guaranteed I'm going to get my 1 million back. Now, this hope lasted until 10th July 2013. Until this date, Your Honor, 10th July 2013, my hope did not end, Your Honor. My hope, I was still hoping under hope that I'm going to get my principal money back, because all arrangements that I agreed to where the representations were given to me, not in writing, Your Honor, but orally. Now, in 10th June 2013, the day this set of notice was issued, I got only 200,000 back. Rest 799 was completely rejected. Now, immediately, Your Honor, after that, I have started sending 3 or 4 legal notices to the Standard Chartered Bank, asking them reasons, asking them for an appointment. The Standard Chartered Bank said, we have followed all the requirements of the law. This is all that you are entitled to. We were authorized to make those deductions, and we have made these deductions in accordance with the documentation available on record. Now, Your Honor, how can the period of limitation run from a date prior to 2010? 2013. This is the set of notification. This is the only communication that is there on record. Unless they are able to show that there is some other communication or some other record where it was communicated to us and we knew that everything is over. Everything was not over until this relevant date. So I don't want to go into the specifics of each and every article and say what is the period of limitation. Suffice it to say, my period of limitation is this. I have not completed more than 4 years, 7 months. Now, Your Honor, last part of the submission which comes to, there are from my side not just allegations, Your Honor. I believe what has been communicated by my client through its witness statement is the actual happening of an event. My client, Your Honor, pursued us relentlessly and said, my only concern is, I am not worried so much about the loss. I am worried about the way I was treated. I am worried about the information that was withheld from me. I am worried about the way no communication was made to me, no information was given to me in writing. Is it not prudent, Your Honor, that when my account came to a grinding halt, it was frozen, it came to an end, I should have been told that your options, Mr. Bijit Ideas, are as follows. If you put this money in this fixed deposit, you're going to lose this much money. If you withdraw, this is what you should do. Bank should have given me an option. Are they today in a position to show to this Honorable Court any communication, any letter to this effect, where I was told that if you do this, this is what is going to happen? Question is, was bank obliged?
You mean the options in 2009? Since 2009?
Yes, Your Honor. Yes, Your Honor. I mean, I should have at least, there should be some written, Your Honor, the only suspicious circumstances are, if something so grave, something so serious has happened, at least there should be some intimation in writing on the letterhead of a bank. There should be some official communication. Why is it that all communication is taking, in fact, I don't want to waste your time, but Your Honor, if you read this thing, of his witness statement, you will find 30 to 40 emails where they're saying, please give us information in writing. Why are you not giving us information in writing? My clients are Japanese clients. They're very persistent, Your Honor. They follow every day. I have seen the communications almost at one time. They have communicated regularly with them, asking for information. So, Your Honor, on the issue of limitation, I don't want to go into this because it is something which has been clearly argued and set out that limitation is not a question even for discussion in the incident case. It can only be used as a technical argument to come out of the situation, but I've already laid out my ground, so I don't want to argue on those points. Now there are two cases, Your Honor. Very briefly, I want to touch upon. One was Kishanchand Gangaram Bhatia's case that was read out to this Honorable Court. It is Volume 1, Authorities Bundle, tab 16, page 136 and 137. This I may want to, Your Honor, just indicate to you just the relevant paragraph, which is paragraph 28 and 29. Because my learned counsel said that the courts made an analysis in this regard. He has referred in his skeleton and he says that this is the analysis of the courts. But if you read the very next line, you will notice paragraph 28, the defendant submitted that the loss was suffered when the claimant subscribed for the shares in the fund. So it said, forfeiture became an inevitable consequence of a subsequent failure to pay the further tranches. It referred in particular to Pegasus management holdings, so and so. The matter may arise in course of the proceedings and it is being unnecessary to express a final view for the purposes of this application. It is preferable, so the court did not, as my learned counsel said, this is the view of the court. It says it is being unnecessary to express a final view for the purposes of this application. It is preferable. I do not do so, but I doubt if this is the correct analysis. So I just want to highlight this particular point for you. And the second point that I want to highlight is the Amjad Hafiz case that was read out in this honorable court, which is Volume 1, Authorities Bundle, tab 12, page 73. Your Honor, in this particular case, this pertained to a one-bedroom apartment. There was a design difference, and they held the defendant was liable for misrepresentation, and the defendant applied for an immediate judgment. What was read out to you, Your Honor, was that the judge struck out the particulars of the claim. That is correct. The judge did that. But what was not read out to you was the same judge, while striking out the particulars of the claim because they were not precise, went on to grant leave to the claimant to amend its claim. So this point must be borne in mind, because the defendant had alleged that the claimant's claim was insufficient. 17.43 that was read out to you, it said it was not specifically set out. And the court gave the opportunity to the defendant. So it was not as if the court closed the case. The courts realized that this is an important thing. Now, Your Honor, I want to sum up my conclusion, if you permit me for 3 minutes. Since I have covered most of my points, I don't want to go into repetitive argument. Your Honor, my case, the burden upon me is to bring to the attention of this court circumstances and arguments that would show that I have a reasonable prospect of succeeding in this claim, and it would show that there are reasons why this case should go to trial. The only compelling reason that comes to my mind, if I were to say, choose amongst 50 reasons that you have, what is that only compelling reason that you would say? I would say the entire basis of this claim is the facility agreement. They say a facility was provided to me for 2 million, but there was no agreement in place, and they don't doubt that. They say 4 million agreement was in place, and from that 4 million we gave you 2 million, but I never agreed to a drawdown request. There is no request from my side that I agree, now you draw down 2 million from my account. And that agreement expires a few months later. How can a loan agreement expire after a few months? And why was a new agreement signed? Now, Your Honor, if I look into, this is just an example, There was no written communication, second example, second suspicious circumstances. I feel, Your Honor, in the instant case, there is no witness statement before this honorable court of the other party, because had they submitted a witness statement, the case would have gone to trial. There would have been issues, because what would have happened is, Your Honor, I would have said, before this honorable court decides on this immediate judgment application, I want to hear the witness. I want to cross-examine the witness. And Your Honor, you would have said that this is not a mini trial. This case should be referred to a full-fledged trial. You can do this in a full-fledged trial. Your Honor, in the instant case, I have discharged my burden of proof by proving to you that this application must fail because it has been filed only with a view to take a chance whether this case will come to an end or not, and unfortunately delay the proceedings because they don't want this case to go to trial. My second submission, Your Honor, is that DIFC law, the application of DIFC law, at least, that question cannot, legally it's not possible. You can have an alternate argument only if there is scope for disagreement. You can have a different interpretation of IGPL or equivalent, but you cannot have a different interpretation of the applicable laws. Regulatory laws are substantive regulatory laws. They are the law of the land. They have been made under a proper law. They afford protection to me. They govern the conduct of a regulated entity. If a regulated entity does not follow the concerned regulatory law, the conduct is called in question. And I, as an investor, I, as an affected party, have a right to knock on the doors of the court and request this honorable court to look into this matter. I did that, Your Honor. The issue is not whether under those 4 agreements that I referred to before this honorable court, the laws of UAE says, laws of Dubai law. The question is, this court will look into what is the most appropriate law, assuming for the sake of an argument that some other Dubai law is also applicable. The UAE central banking regulations are also applicable, but those have to be read in conjunction with the laws of the DIFC. So, on the issue of limitation, I have brought to the attention of the court my argument. Your Honor, the grounds on which they have brought this application are the grounds that are not legally sustainable. They are preliminary objections that could have been addressed in a proper trial. I have lost time, they have lost expenses, we have incurred huge expenses, we are not a big organization, and it has become extremely difficult to defend this trial before this honorable court. I request this honorable court that this honorable court must do one thing more. I know this is not before this honorable court, but this court has the case management powers. In fact, if this honorable court decides to dismiss this application, this honorable court must also request the CMC to be held immediately within 5 days or 6 days of this of the judgment, so that a proper timetable is framed in order for this trial to proceed. Thank you, Your Honor.
Thank you. Just maybe the only issue, if you would like to reply on the fraud and mispresentation. You've heard a comment from the claimant, from the applicant about not filing the details about this in your statement of particular for claim. So would you like to comment on this?
Yes, Your Honor, of course. Your Honor, my entire, the amount of information and details I have given in my witness statement. There are 2 witness statements that Mr. Bijit ideas have filed, and the annexures that are there. If all these things are read together, Your Honor, issue will become very clear. Your Honor, the biggest fraud on the face of it, or the biggest misrepresentation on the face of it. I'm sorry, these words don't look right to fraud and misrepresentation always brings to mind a negative energy and negative thoughts. But the truth is that even if I have submitted nothing, if this honorable court were to look only at one point, which is, was there any communication from their side to us in writing of all that has happened, then that non-communication on their part is itself a cause for concern. Itself adds to the fraud and misrepresentation. But we have not relied on that. We have relied on specific instances of fraud. We have given information And they have not even responded in their defense, or they have not even submitted a witness statement to say they are wrong. Your Honor, in law, unfortunately, in law of pleadings, the rule is very simple. When one party alleges something, the other party must respond and must give its view on that subject. If the other party does not specifically, not generally, does not specifically deny those pleadings in question, they should be deemed to have been admitted. Our presumption is, based on what we have seen today, they have lost two rights today. They have lost their right to file an amended statement of defense. Now, if they want to file an amended statement of defense, they will have to seek the leave of the court. This is something that needs to be looked into, Your Honor. But for the purposes of fraud and misrepresentation, I don't know, Your Honor, if we can go into a mini trial, but I have all the voluminous documentation to demonstrate, and I can do that after lunch should you prefer.
Thank you for that. Now, for the applicant, would you like to have comments on this, or would you like to take a break and come back after lunch for more time?
I do have a few comments.
Yeah. Okay, so we'll break until 2:30, probably? Yeah, 1 hour enough?
Yes.
Yeah? Is it enough?
Yes, sir.
So we'll break until 2:30, then we'll come back. Thank you very much.
All rise.
Hello.
Hello.
Hello.